May I permit to mention one matter for restoration?
Mention on Friday. Oh, today is Thursday.
Today's Wednesday, Your Lordship.
And give notice and mention tomorrow. Yes. Yes. What happened?
Yes, Lordship. Lordship, upon instruction, I am submitting, Lordship. I had a detailed conversation with the petitioner over telephone. Lordship, she had just requested, Lordship, she wants to avail the last chance as per the norms, as per the last Lordship instruction, which has been already mentioned, Lordship. There are 3 chances that the petitioner can avail, Lordship. First chance she had availed. Second chance was the DRM permission. The last chance has to be from the general manager. The permission has to be granted from the general manager, Lordship. The last chance, if Your Lordship, she wants to sit for the last chance. If she passes, if she qualifies, that is okay. And if she doesn't, she will admit her fate. Then she can carry for. She can take the appointment on Lordship Group D appointment.
Where is the last chance provided?
Yes, Lordship.
Kindly see the rules, Milord. I'm sorry, Mrs. Mark.
Yes.
Kindly see it.
3 chances
It has
are
to be
there.
done as per the approval of the GM.
Yes,
2
Lordship.
chances as per the DRM has own power to give her chances, but the last chances it has to be approved from the GM.
So will you allow Mr. Mojumdar? Is there any possibility? Third chance?
Yes, she can apply it to the GM. So, Milord, accordingly, GM will take a call. Milord, as per the rules, third chance is, Milord, it can be done. It's not that it cannot be done, but we can allow it, but subject to the approval of the GM. It's a little time-taking process. Maybe 1 or 2 months is required. 2 months is required. Milord, this is the, Milord, the same thing we have communicated to her also on 6th of January. Milord, kindly see this. See the last para. Hence, as per the extent rules, you may submit application for recruitment cell so and so, either for appearing third time for grade C written examination or opt for D category for the post. But we have given proposal earlier also. Let her join in group D, and there is an internal the examination also where she can avail group C, group B. She can. There is an internal process also.
If she joins, then also a permission has to be taken as directed by you.
No,
Then he can appear in the forthcoming
That's a
first chance.
that's the departmental process. If she joins in group D, this rule will not follow, then the departmental process will follow. And there, there is a provision for her appearing for the examination, internal examination.
So you join, secured your job. Thereafter, your avenue for promotion is open through internal process, as Mr. Mojumdar is saying. So you join.
Or your lordship can direct, subject to your lordship's approval. Milord, asks her to appear in group the third examination, and
that is not certain now when the permission will come, when she will see.
That is the time. That's time taking process.
After December.
At least 3 months.
It is held twice a year.
No, every month, every 10th. 10th of
every 10th of every month. 10th of
In
April.
the third case, GM এর যেটা 2
But
months.
third time that approval has to come from the GM.
অবুঝের মতন কাজ করছে, ওটা করছে না কেন না সে ইউজুয়াল departmental examination will be as per your rules.
Yes.
That does not, may not permit that every 10th of month. it
No,
will
no.
be.
That is no. Well, that is not. That is a departmental examination. But as per the rules, this will be conducted.
But Mr. Mojumdar, suppose we relegate her to this permission issue and it is refused, then again a problem arises.
As per the rules, my lord, she can avail 3 chances.
Now, yes.
Two by the
what is your
DRM directly.
instruction, Mr. Mojumdar, permission will be granted.
My lord, that my lord, it is very my lord, difficult to my lord, commit before this court on my behalf to say my lord, whether it will be granted or not. But your lordship can ask the GM to consider my lord, consider the entire my lord, after considering the entire backdrop, your lordship can direct the GM to consider her case and take a appropriate decision within 2 months.
আজকে এই মাসের তো হয়ে গেল। Seeing now, madam. Suppose we record this and send it to whoever it is, general manager, somebody. And if he doesn't listen to this observation, then again question will arise whether he would be in contempt or not. Because we cannot force him to say, we cannot persuade him to say that yes, permission will be. That is the
Absolutely.
official formality, it has to be done.
Completely understood, Lordship.
It's okay.
I keep it to your Lordship. Whatever.
If he appears third time, last chance as per your instruction, and he could not succeed, but ultimately join Group D, then whether he will be able to appear for Group C examination or not?
No, then the internal process will follow, my lord. The departmental process will follow. After joining Group D, my lord, there are provision but for promotion. That rule will follow.
Obviously.
তখন সেটা every 10th of the month তাই দিয়ে দিয়ে Mr. Mojumdar, the learned deputy solicitor
The time for the application. Next is after filing of this writ application. Is the original.
What is this?
And this is the certified copy. I have filed this writ application by pursuant to the leave of your lordships by a server copy. My lord, subsequently I got this certified. My lord, this matter pertains to my lord second SLST selection process.
Just two.
Lordships.
इलेवन ट्वेल्व में तो कट ऑफ रीच करेंगे
Mr. Ghostu, we fail to understand how callous a candidate can be.
Yes. It is true, my lord, indeed.
They are conducting selection process of lakhs of candidates. And you come to the read court that I have committed a mistake. Please
My
pardon.
lord, only, my lord, only.
Is this expected?
My lord, only.
Now, suppose you put yourself in the shoes of the candidate.
Yes, my lord.
You have lost your job. Next examination given. Still you people are not
My lord,
careful.
I have talked with my client. It is hard contention. It is a technical glitches. My lord, I don't believe so. But hard
She
contention.
has become already the professor,
My lord,
na?
only, my lord, in this.
She is dictating her own terms. Oh, no, I have not committed mistake. It is
My lord,
expected
because, my
commission.
lord, I can understand from my learned friends.
So
side,
how
my
many
lord,
times
several
we can-
candidates, my lord, they have filled up rightly, my lord. That was not, my lord. In this conspectus, my lord, may I humbly pray, my lord.
Yeah, there is also a notice to edit.
My lord.
One notice was given to edit. Given.
Yes.
I have seen in another.
Yes, 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 my lord.
That was এখানে
my lord,
আছে, এখানেও পড়েছে।
They have not annexed. One was
Yes, 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 given.
কপি দিন আরে মাইলরকে কপি দিন ভাই
Commission has permitted to edit their
Yes,
forms
yes,
in the month of such and such.
August.
So you have
My
not
lord,
availed that also.
my lord, in these
আচ্ছা
circumstances,
কি করবো এখন
my lord, in these circumstances, my lord, I am relying on division bench order passed by, my lord, passed by the honorable coordinate bench. My lord, similarly situation, my lord, they have failed to update their credential. The honorable court ultimately
now
decided
results have been declared.
result written examination, my lord, has been examination declared. My lord, only, my lord, may I humbly pray, my lord. My lord, only this, my lord, I am praying only since, my lord, my appellant filed and written application before the authority. My lord, kindly direct the authority to consider it, and these orders shall not be set as a precedent, my lord. This order I am praying, my lord, for the sake of the. Otherwise, my lord, they will, my lord, a petitioner is, there is a shortfall is
Withdraw the
11
appeal, make a representation. Who is stopping you?
My lord, only observing that, give me liberty to file a fresh application. This much, my lord. I am withdrawing this appeal. My lord, give me liberty to file that application. My lord, it is the, my lord, my lord, only, my lord, why I am praying so?
Another meaning.
My lord, why I am praying so? My lord, why I am praying so? My lord, 11, 12, my lord, I have out from the competition. In 9, 10, my lord, only my hope, I have a shortfall of 10 marks, 9 marks. If 10 marks, there is a substantial right. It is admitted position. I am working in a previous school. But in shortfall in 9 marks, if 10 marks added, I shall be promoted in next round. I am not claiming the job. I at least promoted to the next verification of documents.
9 months means you have a.
I have 9 marks shortfall in, my lord, 9, 10 class 9, 10 selection process. My lord,
Now, what is the experienced rider?
yes, my lord, this is the result. My 10. 10. My lord, this is my result, my lord. It has come subsequently, my lord, because after filing of writ application, my lord, I have secured, my lord, 50 and cutoff is 59. 59 is cut off in 90.
No, prior for past experience, how many
10,
marks?
10. If 10 is given, I shall be promoted in the
So you have 10 years experience.
10 years, 10 marks. I have that, my lord, I have that experience.
What is the prior permission rider that you have if you have a past service of more than 10 years?
No, my lord, it is 2 marks. Koto dada? Koto kore? 2 marks
You
is
know, please see page 46.
46 rule. I have the, my lord, I have 10 marks, entitled for 10 marks. In 11-12, they are given 10 marks. In 11-12, my lord, it is I am obtained 10 marks. Kindly see the 11-12 result also.
So have you more than 5 years
Yes,
teaching
yes,
experience?
yes, my
More
lord.
than 5 years.
Yes, my lord, kindly see the page 55 of my stay application. In 11-12, I obtained, my lord, so with similar experience.
Prior teaching experience is 5 marks.
No. 10 marks.
10 marks, 46.
Wait, page
46 below the box.
below the box.
Schedule 2A,
No, means na.
page 46.
46, my lord, 46. Prior teaching, no.
45 it should be. 46, no, 45. I'm sorry.
Tomatte 40, amatte 45. No, how to means?
45? Well, schedule 2.
46.
46, yeah.
Prior teaching experience 10 marks.
10 marks.
Prior teaching experience of how many years? At the secondary level?
At the secondary level in a government or government aided or government sponsored school calculated on the basis of 2 marks for
Yes,
each
part-
year of service
each year.
in a substantive post as permanent or on a contract basis.
I have that requisite qualification. In 11-12, my lord, I rightly filled up my form, and the authority is allowed by
So
10
you
marks.
have you have prior experience of 5 years.
More than 5 years, well, at 8 years, near about 8 years. Or 7 years. My lord, kindly see page number 55 marks. It is my 11-12 result. 11-12 result, this candidate rightly filled up the form.
55 what you are showing?
Yes, my lord, result of 11-12. My result of 11-12, written examination result of 11-12 selection.
11, 12
Yes.
years.
10 my experience scored 10 marks. They have given
Experience where? Experience 10 marks.
10 marks. My lord, I am putting this question. I am working as an assistant teacher. My lord, substantial right
So
is there.
if 10 marks is given to you,
I
you
will be-
come within the zone.
No,
Huh?
no, so shortfall of 9 marks.
What page?
Shortfall of 9 marks in 90.
If total score page is 60. Oh, shortfall.
No, no, total.
Yes. No, 9 marks. Total marks I obtained 50 and cut off 50.
Zero.
Cut off 69.
59.
It is 69.
No, 59, my lord. It is
করে
59.
বুঝবো এখানে it is printed
59, cut off 59.
এটা 5 ও এই যে একই রকম এটা ওই যে
ওই যে
40
জিরো দিয়েছে এখানে 10 দিলে
10 দিল 60 হয়ে যাবে।
Only this much. Well, otherwise, well, even my lord,
11-12 পাচ্ছি।
yes Mr. Bhattacharya.
kindly set as a not to set as a PCTM. Please sort.
The previous matter where your lordship wanted Mr. Bandyopadhyay to take instruction is regarding participation. He missed the bus regarding the date. Your lordship recalls, a few days back. This is not such a case. If this departure is made,
What happened in that case?
she was allowed. She was allowed. Justice Boschak was looking into a matter of a different dimension altogether, my lord. SC became general and this issue was there. They wanted to edit, they failed, they missed the bus. Justice Boschak gave them a window, my lord. Your lordship saw the order in Somnath Pramanik. My lord gave a window up to a particular time, whatever writ petitions are being filed, only those persons up to a cutoff, only up to a particular day, starting, my lord, the order was passed sometime around 2:30, 3 o'clock on a particular day, and it continued till next day, 9 o'clock. that window was opened,
24
hours. And whoever comes, whoever has filed was permitted. Here your lordship is looking at a case, my lord, please see 61. He admits that there is a mistake on his part to update. But if today this mistake, my lord, there are thousands of candidates like him who will, my lord, be, my lord, gaining, my lord, a foothold despite, my lord, not coming within the zone. And this writ petitioner, the writ petition was filed, my lord, after a considerable length of time. My lord, kindly, my lord, with greatest of respect, my lord, this, my lord, the authorities, my lord,
When the examination was held.
Examination
14th of
7th November, 7th September 2025.
7th September 2025.
In 9/10 and 11/12, 14th of September 2020.
And when you filed the writ petition?
Writ petition in the month of November.
Writ petition is in the month of November. My lord, I could have understood, my lord, he comes to your lordship's court, my lord, immediately after missing this date. Missing this date.
My lord,
The edit option date.
my representation just after, in the month of September. It is true, my lord. In the month of September, after examination, I made a prayer. That I have substantial right, let it be considered. But since I have committed a mistake.
Result already published.
Yes.
Written, only
My
written.
lord, in the
But
11-12 where he has given the experience, my lord, he doesn't come within the cutoff.
Oh,
11-12.
have
So
clear-
9-10 now is his hunch.
so
He
11-12 result was declared when?
My lord, I'll just give you a lordship that 15th November, the cutoff is 67 and he has secured 65.
15 November.
Yes.
Now, when was the writ petition filed?
19th of November.
ওইটা আনসাকসেসফুল হওয়ার
Yes,
পরে
yes.
রিটটা ফাইল করেছে।
Yes.
Now, today, if
Good
this
public-
person is permitted, my lord, then someone
My lord, only give
will have to be, my lord, shown the door.
No, my lord, your lordship kindly pass this order shall not create any
This
and my lord, give me liberty to file a fresh application before the commission. My lord, for sake of my life. I have committed, my lord, it is not a fact that I have stated that I have averted in return.
On what basis we will pass that?
My lord, since
Show us
yes,
something.
my lord, in this, my lord, Honorable Supreme Court says, subject to correction, Vivek Paria's case, Honorable Supreme Court relegated all the matter to the High Court and said, my lord, this my understanding, may be wrong, my lord, I gave the compilation that all untainted candidate should not be deprived by new rules. That Honorable High Court may see this observation. I kindly see this Vivek Paria. So I am also situated in the same situation, my lord. I am a untainted teacher. There is I have lost my job due to some, my lord, there is no fault at all. I am untainted,
Yes.
nowhere my list.
Tainted, untainted question does not come here. Whether you have teaching experience, they have given marks for
Yes,
the
yes.
same. When you mentioned in your application for 11 and 12, they have given. They have not treated
Yes.
you differently. So they have given that number, but it is for your fault.
Yes, my lord, I can understand.
One fault you miss to mention the same. And second fault, you have approached a belated approach.
Both are
Belated approach after publication of the result.
you don't think.
before publication of 9/10, but after
After
publication of 11.
publication of the result.
11/10. But before publication of 9/10. I have come before publication of 9/10.
No. 7th September 2025 was the date for 9-10
Written examination.
written examination.
Examination.
So this result was declared on
Just very recent. After filing the division of honorable before your lordship, just it was
when was the written test for 11-12?
14th September.
So 14th September.
Yes.
That was result was on 15th November.
November in respect of 11/12.
11-12.
Then, my lord, very recent, just few weeks back, my lord, it has published. Time. I have come before publication of 9/10 result.
It will affect the right of others also.
My lord, only my lord, relegate this matter to the commission, take a interest. Only this much I am paying. This was question of my life. No, my lord, your lordship may say this order shall not create as a precedent. My lord, your lordship observe this order shall
How
not.
can we say it can be prevented?
Because my lord,
It's not a
yes,
how can in every matter we say, then the court will question us that what according to you is the precedent. If you take the appeal court to be every matter
My lord,
not to be treated as
I
precedent.
beat application, my lord, beat application I made only prayer to
Then
consider my
states-
representation before the authority,
Mr.
which is
Chaudhary.
prior to my, which was
Say, listen to what my brother.
Since you have committed such mistake, one person has come. And now we are snatching away the right of that person, which has accrued to him due to your own fault. It is a competition matter.
yes, 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 yes.
It is a competition, totally competition. If one person commit mistake, another person will get advantage.
No, my lord,
If I show some leeway to you, give leeway to you, then the person who have gained the advantage, he will lose.
yes, my lord, but my lord, I am submitting several
You
candidates.
obtain,
My lord, several candidates, my lord.
if you come within, if you 10 marks is given to you, then the person who has now come within the zone will be ousted.
Yes, yes, is true.
If your absence, for your absence and for your mistake, another right has accrued in favor of another person.
But my lord, several.
Suppose today we allow you,
Understand, I can.
his right will be affected. What wrong he has
My
committed?
lord, in Pinto Mollik's decision, my lord, similar order passed by the honorable single bench, and my lord, authority carry forward this order. Pinto Mollik, similar considering the representation, I am paying same relief.
What order has
My lord, kindly see. It has carried forward by the authority.
been?
It has carried forward by the authority, considering the representation, only considering the representation. I am praying, I prayed honorable single bench only, same prayer, my lord, same relief, only considering my representation. Yes, yes, Pinto Mollik. এই যে আমি তোমাদের কম্পাইলেশন দিয়েছিলাম, জি আমি দিয়েছিলাম, ওই অর্ককে দিয়েছিল একটা, এই সেটটাই দিয়ে দিয়েছিল।
সেটা কবে দিয়েছিল?
Into what order you are showing? This is for what? This is 9 and 10.
9, 10 or 11, whatever, well, 9, 10, 11, 12.
This order was passed on 6 November
Yes,
2025.
Yes, yes, well,
That means before publication of the result.
before publication of result, my lord, before public, I have my prayer, my case, when I approached to the honorable single bench, that time result also not published. Kindly see that order impute. Order was that time or result also not published. It has been observed by the order in the order impute. They have stated that we are going to publish the written test today. It has not published. After, my lord, 1 month order result has been published. Kindly see the order impute. Why, my lord, honorable single bench rejected my claim?
তুমি ঠিকই বলেছো, এই যে 59 পেজ যে ঢুকেছে সে আউট হয়ে যাবে, কারণ ও তো 10 নম্বর পেজ উপরে চলে আসবে। Now, what is after written test? What is the next stage?
Verification of document, verification of credential,
Then
then personality test.
So personality test. This person who got 59 will be called.
59 will call.
So today, if you are allowed, this 59 person will go. 59 will not get a chance.
No,
If you are allowed, then you secure 60 marks.
Yes.
Then when you secure 60 marks, the candidate who secured 59, he will be ousted.
Not, my
Will
lord,
it not be?
because the ratio is, my lord,
The
1
cutoff
post
will be
1.4.
The cutoff
1.8.
will be 60.
My lord.
If you get 10 marks, you will be 60. So 60 will be the cutoff for written examination. So after, why no?
No, my lord, 59 can person who secured 59 also verification of document. Whoever called
No,
for
59 he will not be called for verification, because up to 60 persons will be called. So how he can be called?
Subject to correction, my lord. Subject to correction. I may be wrong. My understanding is, my lord, cutoff, several candidates are there who secured 59. Several candidates are there.
Who secured 59? So all of them will go.
All, my lord, 60, I have only one candidate.
So when a person lowest marks cut off 60, how can a person of 59 can get into enter the domain? Can he enter?
No, my lord, ratio, but
What ratio? Explain to us. Yes.
So, my lord, one post, in one post, 1.8 ratio will be called in in the interview.
Yes.
1.8.
Yes.
8, 1 point, so
So
2.
if the person securing 60 is available, whether the person getting 59 will be called. Ratio, where ratio apply?
Ratio 2.
1.1.2, 1.5, most probably
In
1.5.
respect of
Against one post, 5% will be called. If I have 7 or 8%, I shall call 5. So last 3 will be cancelled.
But my lord, subject
will be
to
deprived.
it is true, but there is a substantial right in favor of it. Since I have my lord, it is not a fact that I have no
Not
substantial right.
substantial
I
right.
have a previous experience, but due to technical glitches, I missed the bet. Only my lord, I am playing only similar to my lord, only considering my representation. That much only I am playing. Let
How can we say that?
only this much, my lord. The authority may take a decision. They can allow it or not. Since my lord, Pinto is there, since my lord,
Please explain to us. Suppose today you get 60. Persons who will be called for personality test is 1:5. Suppose. So for one post, 5 candidates will be called. So those 5 candidates who would be called has to come within the cutoff. So
1%
if the cutoff is 60, then a person who got 59 will never come within that ratio. Can he come? We may be wrong. Please explain to us.
my lord,
If you are allowed to party, if we direct that you consider, upon considering what they will say, they will add 10 marks. There is no other option because 10 marks added in 11, 12.
11 to
So once you get 10 marks, your score comes to 60.
1% will deprive.
Huh?
1% will deprive.
So how can we deprive them? Tell us.
But
The
my-
right
I-
which has accrued in favor of a person due to your mistake will be ousted from this election process. And you are saying, let it not be treated as a precedent. How not precedent? What precedent is there?
No, my lord, subject to correction.
No, no,
I
we
am
could have understood that had your entry would not have prejudiced any person.
Yes,
But
yes.
now today, if we knowing fully well, keeping our eyes open, how can we deprive that candidate? Tell us.
But my lord, similarly situated person, my lord.
File your affidavits. Speech করার দরকার result জানতে হবে। নিয়ে নাও স্যার।
As having heard the learned advocate appealing for the
He's having an 11-12 in the earlier selection process.
Just give me 2 minutes.
Must be.
এই সব
স্যালারিটা বেশি হবে। চাকরি চলে যাচ্ছে তো ওর।
আমার ভাগ্নে একটা দিতেই পারবে,
তাই
ওর তো ওই সময় বাচ্চা হলো, ডাক্তার পারমিশন
11-12.
হুম
11-12 পড়াতো, তাই জন্য 11
একটা দিতে গেছে।
So she was a teacher in 11 and 12.
হ্যাঁ 11 ছিল,
তাই জন্য 11
এই জন্য ওটাতে ওর ইন্টারেস্ট ছিল।
ওটাকে ইন্টারেস্ট ছিল।
ইয়েস নেক্সট।
Item number 3, I'm appealing for the university.
Who is for the appellant?
No, I appear for the appellant. Will kindly looks into your lordship's previous order of 8th of December 2025.
No, what's up? What's up?
Administration page.
Filed, Mr. Sen.
My lord, the thing is this, that my lord, after that order passed by your lordship, my lord, when you, my lord, already, my lord, it has been noted in your my lord's order that on 20th November, my lord, we sought for some documents from Kolkata University. And my lord was kind enough to, my lord, pass a direction that upon all, that so that the matter can be done and my lord, report can be filed. But the report can be filed only after, my lord, receiving the required documents or which were sought for from the colony. But nothing has been received till date. This is my instruction. Yesterday evening also, my lord, I inquired the matter and the finance department said nothing has been received after that.
But I communicated, my lord, your lordship's order, my lord. But I have to take instruction, my lord. Repeat, my lord.
No,
And it is the door.
You didn't have a talk with your client.
Yes, my lord.
You told them.
Yes, my lord.
Still they are not listening to you.
My lord. Well, just now my junior talked, my lord, with the law officer, my lord. My lord, he said, my lord, several documents, my lord.
আরে এই চিঠির
Yes, yes,
পরে
yes.
এই চিঠির পরে কিছু দিয়েছে দেখো
No, no, sir.
দেয়নি
Sir, my lord, it was not given, my lord. My lord, some more time is required, my lord. 7 days, my lord. For a last chance, my lord.
no,
Because, my lord, several
এই,
documents, my
কিছু বলো
lord.
না, চুপ কর।
So
no,
many
this cannot be
Yeah,
done.
my lord, several documents are, my lord, they are asking for, my lord. My lord, some more time is required.
Well, unless your lord,
Don't test our patience. Please don't
Miller,
test
my
our
lord,
kindly, my lord, with forgive me, my lord.
For this reason, my lord, I sent him to talk, my lord, with the law officer, my lord.
When you communicated our order,
My lord, 8 December.
8 December the order was passed.
8
When you
December,
communicated,
I
you
communicated.
show your communication. Now we have to take responsibility whether this.
My lord, don't take me in this way, my lord, I communicated. My lord, of hard copy is with me, my lord, with my chamber, my lord, but soft copy is with me, my lord. আমি communicate করেছি।
No, just kindly seize your lordship's order of 18th of June. This bench, this honorable court's order, kindly seize 18th June order. Unless they are personally directed to appear, they will never comply. They only want to merely buy time. Please see the 18th June order, once.
My lord, I have communicated it on 10th, my lord. And hard copy is also with me, my lord. They have received, my lord, their parcels. This is the only.
Who is your officer? Who is your officer?
My lord, kindly don't call him, my lord. I will take
No,
the,
what is his designation?
my lord, law officer, Kolkata University.
Law officer.
I communicate register, copy to law officer. He, my lord, takes all the responsibility, my lord. Register is nobody.
And the registrar of the university was personally present in this matter. Now,
Yes,
please
my lord,
see,
yes, my lord. Yes, my lord.
please see, now he is saying that kindly don't
Register,
call.
government finance officer,
Justice said,
everyone was
on the very first day when the affidavit was not filed, please see the order of 18th of June.
ঈশ্বর এরকম হয় একদিন আর
Yes,
একটা
yes.
গ্যাপ
No, this is not the. Please do not take it personally.
হয় মাঝে মাঝে।
No, no, no. You are taking us for a ride. So please see the order, 18 June.
So we direct the personal affairs.
Sir, 7 days, it is I'm taking responsibility, my lord. Within 2 days, my lord, I will forward everything.
The last time,
My lord, 7 days.
last time it was undertaken.
It is my responsibility. I'm taking responsibility. My lord,
Don't
fine.
humiliate yourself, mister.
My lord,
Why
fine.
you
My
are
lord,
humiliating
it
yourself?
was my duty was, my lord, to give
Now, what duty you
reminder.
have?
My lord, I have communicated, but I could not give reminder, my lord.
So when they doesn't listen to their law officer or legal advocate, then they are not fit to be there.
My lord, no, kindly don't take it in this way, my lord.
No, what way we will take? From June, the issue is continuing.
My lord,
Now,
this is the
next,
last-
you are saying 7 days. You will, Mr. Sen, next day will come that no, we didn't get it. Just
Within
now we
2
got
days,
it.
my lord, we will
How
supply.
can we file the
My lord,
report?
within 2 days we will supply, my lord. Today, my lord, is Wednesday. By Friday, we will supply. By Friday, my lord. I am taking responsibility. As the officer of your lordship's court, my lord, I am taking responsibility. My lord. By Friday, we
Don't
will
make this sort of prayers before the division.
taking it. My lord, I am taking responsibility as an officer.
It is because of him, my lord, this is happening. I request your lordship to kindly go through your lordship's previous orders.
My lord, that
Because
is
they do not
everything
take,
is,
my lord, the court, they take court for a ride. This is how they are conducting. Kindly seize the order. In spite of our early detection, the university has not filed an affidavit. The submission on behalf of the state also appears to be unsatisfactory. Under such circumstances, we direct the Vice Chancellor or the Registrar of Kolani to be personally present, as also the Finance Secretary on the adjourned date. On the adjourned date, both of them appeared. On the adjourned date, 30th June.
yes, my lord.
Then also they did not file an affidavit.
They
Then also they did not. And Milord, it is not Mr. Sen or Mr. Chaudhary in their clients. Every time the matter is taken up, either way it is getting adjourned, just because Milord, this correspondence issue is going on.
What is the main issue
The
involved?
main issue, Milord, kindly seize the order of 28th October. 1st May 2025. The entire issue is recorded by a coordinate bench. 1st May 2025. Copy নেই order এর? Judge সাহেবকে দেওয়ার জন্য? দুজনের ফাইল থাকে না? On 7, we directed the state to take instructions.
Just a moment.
I'm sorry.
সংক্রান্তিতে এত রাখতে আছে
So, what scale of pay are you getting?
Milord, we are getting, Milord, on a 10,000, 8,000, 7,000, or maybe 11,000 a month.
And what is the amount being received by the Animal Husbandry University?
Yes, supplementary affidavit, Milord, it's a part of the supplementary affidavit.
No, how much they are getting?
Milord, approximately 24 to 26,000 a month. In some cases, 33,000 also. Now, today, Milord, this is my entitlement. Page 13 of the supplementary affidavit, Milord. 1st March 2024, Finance Department memo. Milord, a person who is in Group D, who has completed 20 years of service, Milord, the remuneration is 37,000. And this has been granted to other universities also, Milord. That is what we have said.
One thing, my lord. My lord, this is the Animal Fishery University, separate university. My lord,
You
government-
don't say anything. The less you say, the better will it be for you.
In pursuance of the order of 1st May, Since the affidavit was not filed, in June, my lord, the order was passed. Both of the learned, my lord, honorable officers, my lord, honorable registrar, the finance secretary, both appeared before this honorable court. They assured the honorable court that he is going to personally look into it. And therefore, my lord, the personal presence was avoided. And now, my lord, the determination changes. And my lord, each time, if your lordship kindly recalls, my lord, they just come and seek, my lord, some mercy from your lordship's court. And on the last occasion, it was Mr. Chaudhary who made this submission that within 2 weeks it is going to be furnished.
Well, why those documents were required pursuant to my lord's order is there. Then, my lord, when it was my lord placed before your lordship that all those circulars or notifications, whether applicable to the petitioners or my lord, the appellants or not, that will depend upon certain facts and circumstances and conditions mentioned in circulars one
Your
after
conduct
another.
shows that they are
So that
entitled,
is
but
why-
it is not being given.
That is why.
Your conduct shows that they are entitled, but you are not giving.
No, my lord, may I tell that, my lord, the whether my lord the terms and
This
conditions.
is just a testing of patience of
Just,
the
my lord,
court.
my lord, the finance, my lord, pursuant to my lord's earlier order or my lord, the coordinate bench's order, finance has to look into, my lord, that is the, my lord, the
Now you passing on the bar.
some papers. No,
Mr. Sen,
no papers we
is it
sought for.
acceptable? A principal secretary will call for a document from a university and on the threat of contempt, and the university will not give, and the principal secretary
lord,
will sit tight.
My lord, it has happened.
If
My lord,
this is the machinery of the state, then we are surprised to
my lord,
we
my
will
lord,
be
my
making
lord, I
comment.
thought, my lord, may I tell,
There is no faith and trust on
I
this
was
institution.
under the impression that after this letter and which has been recorded in your lordship's order, I think, my lord, everything will be done within time. But my lord, only my lord, yesterday since my lord, we naturally, my lord,
No, Mr. Sen, today we will give him 1 week time.
Yes.
Your principal secretary will say that I was busy. I didn't get, I got it just now. I will
No,
take 2 more weeks
no,
time.
no. Let him, my lord, let him place the all the papers which we sought for, my lord, and lordship give us, my lord, 15 days time to consider the same, and lordship kindly, my lord,
Sorry.
or and minimum period lordship kindly give us because lordship kindly because the unless we go through those papers whether they are entitled to or not in terms of those circulars, that has to be looked into. That is why, and my lord, there is no, my lord, these are the facts, my lord. On the basis of that, this order was passed on earlier occasion. But only thing is that let them place because everybody is not entitled to, only subject to the terms and conditions.
15th July 2019. Whether the 1st March has got any connection there too.
Should the merit be considered?
15th July 2019, corporation such and such or any body which is funded wholly or personally by government of West Bengal. So
My lord,
university.
my lord, today I am not ready with that, my lord, the circular. Or kindly consider. Today I thought, my lord, that this is my predicament. I shall go and place this before your lordship.
In spite of our earlier direction, in spite of our earlier direction,
Mr. Sen, no document.
Acha, listen, Mr. Obtain this hardware copy and you communicate also. ওই প্যারাটা বাদ দিয়ে
Communicate, my lord, again they're going to say that they have not been communicated. Your lordship doesn't know, my lord, what stand the university can take to its lawyer in this particular matter.
ওই প্যারাগ্রাফটা লিখেছো যে as the order has been passed in presence of the appellants are not required to
communicate this order to the respondents.
are not required to effect fresh service of this order upon the said respondents. Yes.
So your lordship doesn't want us to communicate further.
Yes.
There is no question of communication. So again, that plea is going to be taken. That is why I am.
No, Mr. Sen is there when he say he is holding.
Your lordship doesn't know, my lord. It's not about Mr. Sen.
No, if me as Mr. Sen is see,
Not Mr. Chaudhary.
see the legal.
They are not minded. They want these persons to die. They are working from 91.
No, maybe
আশা করি ওরাও দেবে
when the additional advocate general appears, we repose faith upon the person.
Wait.
But see, Mr. Sen, it is done. And Mr. Dotto, it is not there. Your vice chancellor will be here. Yes.
Well, I am for that.
তোমার নামটা চলে যাবে প্যানেল থেকে। এই মুহূর্তে নামটা
The petitioner lost his job, the in 2016 SLST, the participant in the both selection process. Several matter is pending. The next one, your lordship giving the direction for affidavit. That matter, the fixed on the 2nd February. So let them there. No affidavit has been filed. But in this matter, there is no direction for affidavit, but so many matters is they are pending. There is the direction as the filing the affidavit, but some of the matter the given affidavit, but the next one also not the given the affidavit.
next one
5 also on the same matter.
we detected affidavit.
Yes, that matter also direct. But in this matter, you are not lordship not given the direction.
দেখি 5-এর ফাইলটা দাও। In the other one, you have filed your affidavit.
Yes, some matter kindly.
এখানটা রাখো।
This is not kindly see another matter fixed on 2nd February. They are
What these are same matters?
Same matter. Same matter.
Then why didn't you take it up for? Why didn't you pray for analogous hearing? Different matters appearing at different dates.
So many they are different. The land
Then why you are saying same?
I have prepared the list of 10 matter is the.
That way we cannot follow. Another advocate will come tomorrow and say, "This is my list." Let it come in its turn. Asho, Mr. Chaudhary, learned advocate, heard Mr. Chaudhary, learned advocate appearing for the. Yes, you have. He's saying that in other matters you have filed affidavit.
My lord, I'll have to check because.
Heard Mr. Chaudhary, learned advocate appearing for the appellant. Dr. Patro, learned advocate appearing for the commission, prays for leave
I got a school. There are two applications, Section 5 application and stay application.
How many days delay?
Section 5 application. Only to a. No.
My submission is totally incorrect submission. It is not 12 days. You will kindly see.
"21 days. 21 days.
Yes.
Are you opposing?
Yes, my lord. There is no explanation. You will kindly see in the it is not maintainable at all. There is no explanation of the dealing period. And that is 21
days.
He has stated 12 days.
আরে ভুল বলেছে 21 days. Why you are opposing?
No, I am opposing not in this. No explanation is there in the application also.
Yes, what is your matter?
Well, before dealing solution, there is instruction from the school. All necessary papers is there. That is all necessary. My lord, all necessary papers is there.
Section 5.
No. I'm with the school.
State.
You are for the school.
My lord.
Yes, Mr. Haldar.
My lord, can you see the order they have landed on a single bench passed order? I am the senior most teacher in the said school. Not only that, the authority is going to appoint the teacher, Reshmi Sarkar. She was my student. So this is the gap. Not only that, earlier, my lord, kindly see last annexure P7, page 20.
Page 20.
Page 20. Stay application.
Yes.
Earlier, my lord, I was appointed as assistant teacher, headmistress.
Your Bidisha Sarkar or
No,
Bipasha?
earlier, the teacher in charge.
Achha.
And on that basis, I was appointed there as assistant headmistress. I worked for some time without considering that the appointment has been made to the Reshmi Sarkar, who earlier consented for headmistress, assistant headmistress of the school. My lord will find that is not in the record.
What you are showing page 20?
That is the appointment I have already got in the said school.
As the teacher in charge.
Teacher in charge, and my lord, assistant head mistress, public PIC.
Very good.
I was work there as assistant headmistress for some time on the basis of this, and I became the assistant headmistress of the school because of senior teacher.
Show us the rule of appointment of assistant headmistress.
Rule.
Selection process was conducted. Panel was prepared. Have you?
I appeared in the selection process.
So, Mr. Bhaldar, there is a recruitment rule.
Yes,
Recruitment rule says that there has to be a preparation of panel.
yes,
Now you participated in that selection process. Panel was prepared.
yes.
Panel was approved. The person who stood first has been given appointment. What is the wrong in the order? Your previous qualification service as assistant headmaster come TIC. For that any marks is provided under the guidelines. Show us that you have not been given that marks. That is why you have been ousted.
And Lordship, first candidate
আবার
already.
কথা বলে।
Sorry, my fault.
Page 42, give a copy to him. Give a copy to that. This one. Thing which you have filed just now.
Report. Only one report is there.
পারমিশন নিতে হবে সিলেকশন কমিটি হবে
তাই হয়েছে।
হ্যাঁ সিলেকশন কমিটি থাকবে কিভাবে তারপরে এক্সটার্নাল এক্সপার্ট
পুরো ও অ্যাপিয়ার করে
প্যানেল প্রিপেয়ার হবে
panel has been approved.
Panel is already approved, already Lordship, appointment is made, joining already.
How can we help you, Mr.
There is Lordship appointment letter and join.
have you given that rule
Nothing.
yes 42 page 42 give it to me. There is a prior permission is to be taken.
Yes,
One
prior permission
selection
only.
committee is to be formed. Thereafter, after preparation of the panel, it would be sent to the DI, it would be approved.
But my conclusion is twofold, man. I worked earlier as per
Earlier you worked.
I worked there as an assistant. They have not considered that, and
There is no provision to that effect, Mr. Haldar, under the rules. Under the rules, there is no provision that you will be given any marks for the past service rendered as AHM.
not only and the senior most.
কি করে help?
And the third one is
Upon
third one is student teacher ratio. That is the vital part of this matter. My lord, the going to be appointed, she is MSc statistics, MSc statistics. But there is no student or only one or two students in that set semester, set subject. And she got the appointment as per my learned friend. Let them consider this.
what is the, when did you file the writ petition, Mr. Haldar?
That is before the petition was filed.
You have not annexed.
Nineteenth of August 2025.
Did you get any interim order?
No. No.
When was the interview held?
Interview was held
11th August.
Given that.
August, state interview held.
My lord.
He participated.
He participated. He positions third position.
After your
Now Reshmi Sarkar has been appointed.
Appointment, he first position, approved the panel, appointment letter there, he joined also. He is the first candidate.
Upon hearing the learned advocates appearing, the present appeal has been preferred. Challenging and order dated
He responded DC. Oh.
I am for the appeal.
No.
My lord, in this matter, I am appearing for the teacher in charge respondent number 5.
About the school.
There is an application under section.
Yes, there is my lord, delay of
So far, my calculation is 273 days delay.
Section 5
Apart from the scam reporter, what he said. But I have filed that application.
কদিন ডিলে করে 273
What have you now? After your resignation, the person, you are the person.
No, I am for the school. He is the person.
He is the person.
Then who is working as the TI?
I am working.
But what about that interim order which was passed?
But
18th April 2017, what was that interim order?
Kindly have a look this order. I shall hand it over.
My lord, this is the order.
Tell us now, what is the order? Tell us.
Order, my lord, he resigned. Thereafter, my lord, he sought to be reinstated. That was challenged, and this order was passed. Into
That
I will work. Sly would work.
Against him.
Yes.
My lord, kindly have a look the 18th April, sir. Unless, my lord, the condemnation, I cannot enter into the merits of the.
There's a hurdle of
kindly see.
section 5 out here.
And that has been suppressed. That was suppressed. And it was going to be dismissed with, my lord, heavy cost. And the junior members are appearing. I said that without imposing cost, my lord, simple case was dismissed.
You are a kind man, Mr.
A kind man, my lord, in that case.
But you don't function in that post. We will allow him to function. You are so kind.
No, because only see the order. And my lord, in one lacuna.
Just
yes.
Where is the 19th of July 2016 order of the DI?
That lordship will find from the stay application,
The stay application.
page 90. 90. 90.
I said, my lord, it is the managing committee to decide who will be the, who will be the, my lord, the teacher in chief.
Very good. Now, after that, managing committee allowed withdrawal of resignation. And that you challenged in your writ petition, which order? This
The purported allowing the, my lord.
Where is that memo that you are allowed to function?
My lord,
My lord, in this order, in the order I have given, my lord, it has been reflected.
19 on perusal of 18th April order.
Yes.
But there is no interim order subject to correction.
There was final order.
Petition disposed of.
Yes.
That writ petition.
Yes.
Setting aside.
Yes. Kindly
There
see.
is no interim order. Court has recorded.
No. Kindly see, my lord. Kindly see. Page 2.
Mr. Mustafa, you are appearing for
Israel.
Bani.
Bani Israel.
Yes.
So Bani Israel preferred a writ petition
Yes.
challenging the order of the managing committee allowing withdrawal of resignation.
Yes.
In that you obtained an interim order.
Not interim order, final order.
18th of April.
Yes. Kindly see, being agreed by, has prepared this. It has been
18th of April says affidavit detection.
No. Kindly see the order.
Bani Israel order 18th April
Yes.
2017.
Yes.
Then final order was passed.
No. That their appointment. No. Let me see. Yes, my lord.
That appointment, that writ petition is pending.
Yes, it's still.
2017.
Yes. It has been submitted by the learned counsel for the petition that once the resignation has been accepted, there is no provision for revocation. And in the case, respondent number 6 is allowed to join, he should be treated as junior to the petitioner. Prima facie, a case for granting interim order.
So who is senior? Bani Israel is senior.
I am senior.
You are senior most.
Has been made out. Accordingly, operation of the order dated.
So you are functioning as the teacher in charge.
Yes.
Now, when did you prefer the writ petition?
Set aside.
Page 49, the order was passed.
In 2025, you preferred writ petition.
Yes.
So you accepted the interim order.
No. My lord, before that, my lord, if you will kindly have a look, my lord, what was the order passed by earlier proceeding?
Which earlier proceeding?
My lord, there are so many proceedings in this matter. My lord, kindly have a look, page 86 once. Of my application.
2016 writ petition.
This was 2016.
Page
86.
86.
18.
86 of the state.
You are Siddiqui Rahman Mallitha.
Yes.
You preferred writ petition earlier.
Both. Even Bani Ismail, both are taken up together, my lord, by.
Bani is also there.
Disposed of.
Yes, that was.
What is the order, my lord? Kindly have a look, page 87.
Yes.
First, page 86, third paragraph. Learned advocate appearing for the state refers to a writing dated 5th May issued by the district inspector of schools and submits that the petitioner in WP number so and so, that is my client, has been allowed to draw additional grade pay for the duties of teacher in charge of the said school with effect from January 2, 2016. Learned advocate writ petition number so and so is also refers to the writing dated May 5th, 2016 of the district inspector of school. In reply, learned advocate for the writ petitioner in so and so, that is Bani Ismail, submits that communication dated so and so has not been made over to his client by the district inspector of school. I have considered the rival contention of the appearing parties and the materials made available on record. Now, apparently, there are disputes as to who should be treated and recognized as teacher in charge of the school. The district inspector of school had called the rival parties for hearing by the writing dated so and so. During the pendency of the writ petition, the district inspector of school has taken a decision as contained in the writing dated May 5, 2016. By such writing, the district inspector of school has allowed the petitioner number so and so, my client, to draw the additional grade pay for duties as teacher in charge of the school with effect from January 2, 2016. Since the writ petition in WP number so and so was not made over a copy of the writing dated May 4, 2016, the same is made over to his client, learned advocate in court. In such circumstances, no further order need be passed in this writ petition. Therefore, the DI, my lord, recognized me, my lord, as a teacher in charge, and that has been accepted, my lord, by this order of Justice Bosha.
No, what has your additional grade pay is being given?
I am placing, my lord. Kindly see.
Your additional grade pay has not been disturbed.
No. Additional grade pay for the respect, in respect of the functioning as teacher in charge. Now, my lord.
Now thereafter what happened?
Now, my lord, kindly see page 38.
30?
38 of my stay application.
Yes.
Now, my lord, subject sanction of teacher. This is 5th May 2016. That I have just read in the Justice Boshar's order. Riddik Rahman Malitha, teacher in charge.
Additional pay given.
Yes, therefore, my lord, I am the teacher in charge.
Wait, that was in 2016.
2016. Now, my lord,
Now, what was the challenge in those two writ petitions, which were disposed of by Justice Boshak? You preferred a writ petition?
Both the writ petition was claiming that they are.
What was the subject matter?
Subject matter recognition of for the recognition of the petitioners as teacher in charge.
And he preferred?
He preferred on that score also.
Achha, very good. Now, disposed of, now 2015 additional grade pay was given to you. Then what happened?
Now, my lord, kindly see, my lord, that thereafter, my lord, another writ petition was moved.
Which one?
My lord, I am placing, my lord. It was
91. 91.
Money.
My lord, page
Money.
91.
Money.
Bani preferred a writ petition.
Page 91.
Now, what is the matter?
He wants to bid with liberty to file afresh, assailing subsequent order of 19th July 2016.
Right.
What is that order?
That is page 90.
90.
90.
90.
Acha, where it was relegated to the managing committee for consideration. Very good. Now that writ petition.
No. One thing they are suppressed.
Come back.
6th February 2017. But there was no liberty was granted.
6th February?
Page
91.
Page 91. So now 19th of July order is at page 90.
90.
I cannot read it. Can you read it?
I.
Oh, you can read it.
This is this
So
was.
there is no system called typing. There is a system. Oh, achha. The undersigned, read the letter.
In reference to the above, the undersigned called a hearing on 15th December 2015 in the office chamber previously on 3rd December 2015. The first hearing was held in the office chamber of the undersigned on 3rd December 2015. None was representing the hearing in the second.
So what was done by this memo?
This memo, but EI relegated, it is the duty of the function of the managing committee to do. This was suspended.
So this was challenged by Mr. Mustafa by a fresh writ petition. Now that writ petition interim order is there?
No. With deepest respect,
No, page, yes.
All right, interim order was passed.
No.
In 18th of April 2017.
Kindly see the 18th of April.
Yes.
Right of now.
Kindly see.
Yes.
Internal page 2. Prima facie case for granting of an interim relief has been made out. Accordingly, operation of the order dated so and so passed by the district inspector school Nodia is hereby set aside. Therefore, this order does not stand in the way. There is no interim order. This 19th, my lord, 19th July order that has been set aside. Where is the interim order? I am putting this question myself.
Then are you working as TIC? You are not working as TIC.
My lord,
so when this order of 19 July has been set aside, that means that the issue of withdrawal of resignation has attained finality. There is no question of reassessment of the same by the managing committee. And are you working as TIC? You are not working as TIC. You are getting the scale.
My lord,
Kindly have a look, my lord. I am placing my
No,
lord.
Mr. Acharya, are you getting the that additional benefit you are getting?
Yes,
Huh?
my instruction is so.
Your instruction is so. Very good. Then how you are agreed?
Because, my lord, in the salary sheet.
Both the read petitions will be heard out together,
Yes,
and as status quo as on date will continue.
because the other repetition is pending. Where
So in that affidavit direction is their matter is pending. So your read petition also you will be heard along with that read petition.
Yes, you are appointed.
DDO appointed.
DDO is appointed.
By the DI.
Now TIC, who is the TIC now?
My client is TIC.
That is your contention.
That is his contention. Actually, he is the TIC. Subsequent, he was also drawing the fund, what is the additional, what is to be made out to him. Subsequently, one fine morning or from February itself, he is suddenly getting the enhanced amount. As per today itself, we are unaware why he is getting the additional amount. That's the difficulty.
Working as TIC.
Now the difficulty is this.
There is no difficulty, my lord. By virtue of this order,
It is not. If he is not allowing this speech, it's difficult. Now, if your lordship kindly have a look at page 29 memorandum, page 80 memorandum. Sorry,
for whom he is managing committee is not the party.
Page 80 is
We
the.
have never met the managing committee as party. So I do not know for whom he is appearing.
The school is there.
No, এটা
School is there.
President of the school.
School is there. And
School may be there. School is not there. President is there.
There is no president. No
Okay,
president.
Mr. Chotto, what is the
At this stage.
Uh-huh.
No president is there.
No president is there.
Hence, already right.
DDO is there.
Administrator no.
DDO.
No, if one question, if Mr. Acharya is not the teacher in charge, why you are paying him the additional scale?
2016, at that point of time, Madhina was the teacher in charge. 2016, the additional was 75.
Then who is the teacher? Why you are not?
He resigned.
Yes.
Israel Madhina appointed as a teacher in charge. Now the management committee allows him to rejoin.
No, after the DI said that the managing committee will decide, managing committee, that order of relegation was set aside. Then the resignation stands.
That's what it's about.
Since my lord July, I am working as teacher in charge. July 16.
How do you take such arduous jobs? You are working as an advocate here. You are working as a teacher in charge. Huh? Mr. Mustafa?
May I place one question?
Resignation is on record.
And my lord, kindly see the order. Where is the where is the illegality in the order?
19 July.
Revocation.
The managing committee, he wanted to withdraw the resignation letter. Allowed by the managing committee allowed him, permitted him, the appellant to withdraw the resignation letter by any order, by issuing any letter or.
And in the impugned order, my lord, there is no illegality. He suppressed, my lord, may I please the order, page 52.
Is he a party in your writ petition? In your writ petition?
Yes.
Headmaster is a party.
Yes. He was party. Kindly see, my lord, page 52 order of justice, single bench, from which appeal has come. During the my lord, from beginning, page 51. The present writ inter alia, petitioner has prayed for direction upon the authority Nodia to permit him to function as teacher in charge. During the course of hearing, learned advocate representing respondent 5, that is my lord me, submits that the present writ petition is not maintainable due to pendency of the another writ petition being WP 6985/2017 preferred by the respondent 5, wherein the issue relating to the engagement teacher in charge of the said school is under consideration. In support of such contention, dated April 18, passed by this coordinator is placed before this court and same is taken on record. On perusal of the order dated April 18, it transfers that the present writ petitioner was functioning as teacher in charge of the said school, who tendered resignation as a result whereof respondent 5, who is the petitioner, petition WP number, was appointed teacher in charge. Subsequently, petitioner in the present writ petition recanted and made a prayer for withdrawal of his resignation, which was first considered by the district school Nadia, and issue was relegated to the managing committee of the school for taking decision. The managing committee decided in favor of the petitioner in present writ petition, whereby accepting withdrawal of resignation had permitted the function as teacher in charge, which triggered writ petition number 6985 of 2017. The coordinate bench passed an order in on April 18, restrains the respondent authorities from giving effect to the order dated 9 July 16 by the district school. As a result whereof, respondent 5 is herein is the functioning as teacher in charge of the said school at present. Said writ petition is still pending final hearing, exchange of affidavits, and pendency of writ petition was disclosed. The pendency of the writ petition was not disclosed in the present writ petition. In view of pendency of the writ petition being the WP number 6985 and subsistence of interim order dated, present writ petition is not maintainable, wherein prayer is made to permit the function as teacher in the school. With the above, the writ petition stand dismissed. So, my lord, they suppressed. Here also they have suppressed.
My lord, kindly have a look.
The order dated, my lord, sir, they are very, my lord, given bunch of papers accepting that order.
Which order?
Order dated, this order, my lord, April 18. It was never disclosed. Passed by my lord Mr. Sharma. April 18, 2017 orders. Thereafter, my lord, I have been working. There is no dispute. Now, my lord, they are, I do not know what prompted them to be so, my lord, proactive to take charge of the teacher in charge. And the school is not party. Managing committee is not party.
In your writ petition, he is a party?
Yes, very much. Kindly see the cause title, my lord.
Mr. Acharya, what is the wrong in the order?
My lord, kindly have a look, page 42 once.
Respondent number 6.
Acha, we heard you, Mr. Hoster. Yes.
And order has been
Resignation of teacher in charge of so-and-so in favor of Siddiq Rahman Malitha, GO number so-and-so. In the matter of continuation of teacher in charge of so-and-so school, president of so-and-so school, Nadia submitted a letter to this office, VD number so-and-so, requesting to continue Siddiq Rahman Malitha, teacher in charge of so-and-so. This letter is self-explanatory. Accordingly, the said letter is enclosed here for your favor of your perusal and for necessary action. But this letter, my lord, has not been challenged by the respondent number 5. Kindly see page 43. Page 43. Well, this is in 2024.
25.
No, page 43, 31st December 2024. My lord, got it.
Yes.
In respect to your memo number so-and-so, that is my lord, page 42. So-and-so issued by the PI of school AC Nadia, Krishnanagar, I beg to draw your kind attention that Siddiq Rahman Malitha, BSc Honors B.Ed, approved teacher in charge, BD number so-and-so, has been acting as a teacher in charge with effect from 2nd January 2016 as per government memo number so-and-so, with full satisfaction, but wrongly a resolution adopted due to make a living PIC. Now the approved PIC SR Malitha B.Ed will be acting continue due to compliance of the government memo number so-and-so, Krishnanagar. So you are requested to change correction of IO SMS portal in favor of SR Malita as teacher in charge as early as possible.
That is why you have sought for implementation of this order
Yes.
in
Now,
your
my lord,
writ
kindly have
petition.
a look, my lord, next page 48. Page 48. This is the page slip, my lord, kindly see. My lord, what is?
No, Mr. Acharya, there is a writ petition pending in which you are a party. In that writ petition, his challenges against
Acceptance of withdrawal of
his acceptance regarding issue of withdrawal and acceptance of the same. Yeah, because the DI has issued a memo on 11th April relegating it to the school for consideration. Now the school on the basis of that taken any decision or not taken any decision, that do not survive any further because the 11th of April memo has been set aside. So your resignation is in operation.
Now, my lord, kindly have a look, page 48.
Your resignation is in operation. And the writ court said that you should have disclosed these facts in this writ petition instead of.
My lord, so far this portion is concerned, I was not there. Why?
So, Mr. Acharya, we are not entertaining the appeal. We will say that you will be at liberty to take appropriate steps in the pending writ petition preferred by you.
My lord, kindly have a look, page 48. Once, page 48.
Page 48. We are not on that, Mr. Acharya. Today,
My lord, it is reflected. I am the teacher in charge.
very good. You argue that point. We are not shutting you out. Court has simply dismissed the writ petition primarily on the ground of suppression of material fact. And that finding is not wrong because you have not furnished all this instruction in the writ petition. In the writ petition, you have only made a prayer, page 31, allow me to why I shall not be allowed to continue as teacher in charge and act upon the letter of this said school, president's letter.
Now, my lord, what I am praying, subject to your lordship kind consideration. My lord, since it has not been done, admittedly, my lord, I cannot say, my lord, because I was not there, no present law advocate on record was not there, who has advised, who has filed this application. Apart from this aspect, my lord, my prayer is, let that writ petition and this writ petition be heard together upon extreme judgment.
How? That means we will be entertaining your writ petition, which has been dismissed on the ground of suppression of material facts. You show us that there is no suppression, we will allow.
Then, my lord, this.
And in the petition, your party, you will be able to raise all your grievances.
I cannot deny that.
Whether acceptance of resignation, your resignation by the managing committee is the subject matter of that.
So you withdraw the appeal, will not pass an order. Withdraw the appeal with take appropriate steps in the pending writ petition. Finished.
We shall say that withdrawal or will not.
That will not preclude.
You.
That will not preclude.
Preclude you progressing your grievances in the.
Yes, we have invited them by making them party in that case.
We will only record that upon instruction you are withdrawing this appeal with liberty to take appropriate steps in the pending writ petition filed by the private respondent in which you are a party. Do you have that instruction? Then again you will be.
That will be a problem.
We don't want to embarrass.
Yeah. Let's come back on the next topic.
No coming back.
No.
Let it be tomorrow so that I can take.
No.
We are dismissing it with liberty.
Kindly,
That dismissal of this appeal shall not.
We will say that. Ashok, the present appeal has been preferred. Challenging
Once again,
I have no instruction, but it is true, my lord, it ought to have been withdrawn, my lord.
on Friday, next Friday, my lord, I'm sorry I could not appear because I missed the list. On the very reopening day.
You're a busy council.
No, no,
what
my
can-
lord, I was not busy.
And
I
Prince-
simply missed.
And my lord,
Yes, call
the
the.
Prince of Murshidabad.
No, 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 not that.
Yes,
Finally.
yes. I know his status in Murshidabad.
I'm a poor man. I'm grateful.
Not appearing for the respondents.
Item number 8, on behalf of the appellants, my lord, I am praying for only 2 days accommodation, your lordship. Mr. Uday Shankar Chattopadhyay is appearing in this matter. He has gone for a death reference.
Then next week, Mr. Bandopad.
Next week in my lord,
Tuesday, Monday,
Monday, no Monday.
Tuesday, Tuesday দিয়ে দিও। আসলে
ওটা
ফাইলটা দাও তো। An adjournment has been prayed for on behalf of the appellant. Any condonation application is there?
No, no condemnation application, only the application for the appropriate
Achha,
order.
an adjournment has been.
স্ট্যাম্প রিপোর্টার ডিফেক্ট দিয়েছিল এটা বলে আমরা স্টেট একদিকে বলে কোর্ট পিছু দাও
My lord, I am appearing for the
for the respondent writ petition
but
স্ট্যাম্প রিপোর্টার একটা রিপোর্ট আছে
this is the affidavit of service and the
এটা affidavit
are taken deficit কেন?
আমাদেরকে বলা হয়েছে ওখানে ইউ আর নট স্টেট পে ফুল কোর্ট পে আর এখানে বলা ইউ আর স্টেট
And deficit court fees has been paid. Yes. Lord, kindly come to me, Lord, impugned order at page 70.
Page 72.
9. No, sorry, page 85. Page 85. May I read it? Matter is heard in presence of the learned advocates representing petitioner, state respondents, and West Bengal Central School Service Commission. Petitioner interior has paid for change of medium from English to
Bengali.
From English to Bengali as petitioner inadvertently is found that he applied for in amount disturb petitioner, sorry, Miller, to petitioner has paid for change of medium from English to Bengali in second state level selection test 2025 for being appointed as assistant teacher in physical science in class 9 and 10. It is submitted on behalf of the petitioner that he applied online offering his candidate for being appointed as assistant teacher in physical science for class 9 and 10 in the aforesaid selection portion, opting English as medium of instruction. Petitioner participated in the written test and is awarded 71. Prayer is made for change of medium of instruction from English to Bengali, as petitioner inherently, while submitting online application, opted English as medium of instruction. It is further contended if such conversion from English to Bengali is as medium of instruction is permitted, petitioner at the time of personality test would be considered for appointment against a post of assistant in a school where medium instruction is Bengali, not English. Mr. Vishwarup Bhattacharya, Learned Senior Counsel, is presently commenting, commission has opposed this prayer at this stage when the result of written examination has already been published. A list is prepared containing names of candidates for the participation in ensuing personality test, however. It appears from the submission made on behalf of the commission that the date of commencement of the personality is yet to be scheduled
In support of such country, reliance has been placed on the judgment of the Honorable Supreme Court. State respondents are also represented. It is submitted on behalf of the parties. The petition on being treated as on candidate aspiring the teacher in physical science under scheduled caste category opting English as member uh, English as instead awarded 70%. It is also upon on behalf of the commission under the category that is assistant teacher in physical science. So the Bengali medium cut-off marks is fixed 51. Therefore, it appears for the petition is permitted to change medium and so and so. In Mohit Kumar Supra Kindi appointed for the candidate consideration for the post of service civil post and so and so. Whereas for OBC category candidate it was 3.5. Put to the candidate being the applicant, then approves the authority for being considered as OBC candidate in order to get the benefit of lower cut-off marks by treating him as an OBC candidate. In the aforesaid fact situation, our Supreme Court did not direct authority to treat the petition as OBC candidate, but in the present case at my hand, if switching over from English medium to Bengali medium is allowed in the event petitioner comes within the zone of consideration, and no reduction is required to be existed to the petition in terms of cut-off marks as petitioner obtained 17, whereas cut-off marks for physical science SC English medium is 59 and physical science being Bengali medium is 51. Needs to also record a hearing that the date of commencement of personalities for class 9 is yet to be scheduled. In aforesaid conspicuous concerned authority of West Bengal Central Principal is directed to treat the petitioner as Bengali medium candidate if the petitioner comes within the zone of considering the marks awarded to him, he shall be permitted to participate in the ensuing personalities. Then is a change of medium. There are Lord, this candidate applied for 11 and 12. Medium is English. He is now working as a teacher as English in the English medium. Now, first he applied for 9-10, first applied for Bengali in Bengali medium. First applied for in Bengali medium. Then another application has been filed by him. There he or she, here he made the application in their Bengali medium. Therefore, in 9-10, two applications are there. One is English and another one is Bengali. First one is Bengali, then second he said English. Our notice has said very categorically, if any candidate files multi-applications, then last applications will be taken into consideration. Medium is English and he has secured first 9-10. He has secured number 1.
Now he wants to change the medium.
Bengali, that cannot be permitted.
But why he is wanting to change? For vacancies?
I do not know, my lord. I cannot say this, that Bengali more vacancies are there. A person who has got number 1, automatically he will pass in and enough mark. 65 is a cut-off mark. He got it 70. Number 1.
I am a 2016 candidate. Since 2020, I have been serving in a Bengali medium school. I was appointed in 2016 in an English medium school. Thereafter, I was transferred in a Bengali medium school. And since 2020, I have been disbursing my service.
That 16, you lost your job. Oh.
I was in a Bengali medium school since 2020.
9 and 10.
9-10. Thereafter,
But you first opted for English language.
At that point of time, I opted for English in 2016.
No, not in 16.
Here in 2025. Here, my lord.
Paragraph 4, prayer is made for change of instruction from English to Bengali.
Yes.
As petitioner inadvertently while submitting online opted English. So you opted English medium and...
Well, here what has happened, my lord. I opted for Bengali medium first. That application was not processed, my lord. Page kindly comes to page 69. It is showing technical, it's showing the status is not being shown. Due to the technical glitch, my lord, I had to again apply. Now in this
Page 69.
69, in the second application, my lord, I made the mistake by applying in English medium.
'69 is error.
Yes.
This
is in
was for Bengali.
This is for Bengali.
Error in login, not in.
Application is at page 66, my lord.
66.
66 is my first application
Oh, yeah.
in Bengali medium.
So there was an error. So you made a fresh application.
Here, my lord, I committed the mistake by applying for English medium.
Page 70.
Page 70.
So when did you find out that mistake?
But I found out the mistake immediately. I went to the office, but the mistake I committed, my lord, I didn't make any representation. I went there. I was told you sit for the examination first, and you come back. That is I have made out that case in the writ petition, my lord. Although I cannot prove it because this person.
Now, when did you make the representation?
I made the representation in November.
Have you annexed?
Yes, page 74. Well, I approached the court before the results were published.
Result published when?
I think 30th. 9/10.
13 December.
13 December. So you got selected in English medium at the highest post, at the top of the panel.
Yes.
Then and in Bengali your rank is? In Bengali there is no rank. No.
I've been considered in the English medium. That is why.
No, it is said paragraph 9. No relaxation is required in terms of cut as obtained 70. Cut-off in English is 59.
Yes.
So you will get the job.
No, he is in Bengali 65 though.
That is
Well, first of all, the first difficulty will be the interview, because the interview for English will be held in English and Bengali will be held in Bengali. Second difficulty will be, my lord, well, even if I get the job, my lord, I'm not that conversant in English, my lord. I will not be able to discharge my service in a proper manner. That is why, my lord, I prayed for transfer in the earlier round and came to a Bengali medium school.
No.
But this is not fortified by the rules, na? You have no legal right to that effect. Sympathy is one thing, but where is the right that you can alter?
But the only thing, my lord, I approached the court before the results were passed. It's not that after the result I have come. And secondly, my lord, I have satisfied I have got more than the cutoff in both the mediums. So I am within the zone of consideration. It is not that I've gone out of the zone of consideration.
No, this cannot be interchangeable. But firstly, what he is saying that's not correct. Because kindly come. No.
Now Bengali result has been declared.
Results have been declared altogether.
Result has been.
So in Bengali the cutoff is 51.
51 in SC category and 65 in general category. I am a SC category, so 51 for me. Yes.
Yes. পরের কথা
ওকে তো তাহলে অন্য পার্সোনালিটি for correction earlier at any time change the medium.
No, medium this was not there. Other fields it was there.
No, kindly see, come to page 60. No. Page 60, kindly come to page 60.
60.
See, page 60. Earlier. 17th August, 17th.
September
2018. Milord, school name kind last appointment dated. BE College, Model School, so and so. Qualification PC with rate vacancy, medium English. So he was appointed in the English medium. Right. Now see his application form. Kindly come to page 66. See.
One
The name of the school working in BE College, Medium, Model High School.
he applied for Bengali.
No, here I am just showing that is therefore what he is saying that I shifted, I transferred, that's not correct. Earlier he was in the English medium, he is still English medium. Teacher is in the English medium working in view of the Supreme Court's order.
So Mr. Bandyopadhyay, if he has to appear now before a personality board where he would be put questions in English naturally.
English, yes. English. There is no scope to change, Milord. Kindly see, Milord, the one.
No, his initial
kindly see, just I want to show you, Lordship.
Page 66.
Kindly come to page 19.
Bengali error.
Milord, kindly come to 18 June 2000. He appeared, he sat in the examination with this application of English medium. He sat in the examination. Long before on 18 June 2025, we have made it clear. See, my lord, this is to notify that all prospective applicants that in case of multiple payments. Page 19. 19. Kindly see, this is to certify for all prospective applications that in case of multiple payments done against a single application ID, where more than one transaction was successful and received was generated against one online payment, refund will be done for additional payment done against the same application ID where receipt acknowledgement was not generated. No refund will be done under any circumstance for successful payments done against multiple applications ID. Admit card will be generated against the last application's ID for the same candidates for one class level. Now kindly see his first application. Error, there is no error. First application.
English medium ক্যান্ডিডেটদের সঙ্গে ওর কম্পিটিশনটা হচ্ছে বাংলা মিডিয়ামে
This is his application form.
66 Bengali medium.
This is the first application.
He applied for Bengali.
Bengali. Then Miller kindly come to this second.
But this was this could not be uploaded due to an
No, unless it has been uploaded, how he has got it? He has annexed this in the writ petition.
Then if he has got it, he would have got for Bengali medium because his application.
No, there are two applications there. Two applications his two applications were uploaded.
Two applications uploaded.
He filed the application. One Bengali application. Uploaded.
No, that was not error. Page 69.
That is login error. Login error. But it was not error ultimately. Then it's we have got it. If the login error.
Oh, thereafter he said that consider me for English.
English. Second application.
Now, when that was pending,
he appeared in the examination. He appeared in the examination, knowing fully well that he is going to be selected in the English medium. Otherwise, he would have objected at that point of time. Prior to that. my lord, good teacher in English is required.
Now, Vita's verification is in process.
No, no. Huh?
Verification
Verification will commence and result has been, I mean, এটা কি বলে? Preliminary interview list has been published.
But Mr. Banerjee, suppose we allow your prayer, then you lose your option to compete with English medium students, competing with whom you have got a quite higher position. It is a question of destiny. Suppose we allow you and you appear in a personality test with Bengali medium questions to be put, and perchance you fail, then your option to be considered with English medium as per the process, you cannot turn back and say that give me that. Is your client aware of this?
My lord, in English medium, my lord, the schools are less, the candidates are also less. But here, my lord, in Bengali medium, my lord,
No, if schools are less, how that will prejudice you? You are competent in English. You have secured the first position there.
examination I have secured the first position. The difficulty will be, my lord, the verbal.
Difficulty is if you don't get the job.
That is one.
You have no problem in working in English medium. You are anticipative that if I come under the Bengali zone, I will get a greater scope of participation.
And my lord, in the earlier round also, my lord, after serving, I was appointed in 2018, this appointment date of the appointment letter.
No, Mr. Banerjee, you explain to your client and come back. Suppose we are not, if we do not go as Mr. Bandopadhyay says, your fate will be sealed.
Do you want to say something?
I just want to add one thing actually. Because the prejudice that my learned friend, when I'm supporting the commission, the prejudice that my learned friend is trying to canvass that I will be prejudiced at this stage of interview because I am not that proficient in English. Let me kindly take page 74, the representation. He has applied for two posts, physical science and physics. In physics, he is saying that put me in English medium. In physical science, he is saying put me in Bengali medium. Therefore, in physics, 11, 12, he is asking for a change of medium to English. For physical science, he is asking for a change of medium to Bengali. That means it is not that he is not proficient in English. He is all right with English, but only because
he is afraid of getting a job.
He is trying to diminish the competition. But the prejudice he is trying to canvass for a sympathetic consideration is that in the Viva it is difficult.
Mr. Banerjee, you take instruction. You take instruction because then if Mr. Bandyopadhyay is arguing, then we have to deal with his points. And if you do not want to go into that hassle, then problem ends, na?
Very well. I shall come back.
Come back. Acha, had Mr. Bandyopadhyay, learned senior advocate, appearing for the
I would have tried for in English
I am for the appellant. Yes, my lord, it's hearing.
Yes, my lord. I'm the writ petitioner, my lord. I lost my job, my lord. It's a termination, my lord, of an the person concerned.
Can you finish it up?
Yes. I will.
And
if he does not allow me, my lord, to speak, then my lord, today, if he continues till my lord 3:30.
How long will you take?
minimum 30 minutes.
Oh, then it's all right.
Other matter release because
30 minutes and he will take 15
pay
minutes.
the 3:30.
15 to,
Why you are leaving the court?
no. I
Yes.
My lord, in nutshell, the writ petitioner, my lord, he was our superintendent. It's a non-faculty post. My lord, while he was in probation, he was terminated with certain reasons. That was challenged before the single bench. Single bench was pleased to set aside the termination. I preferred this appeal. At the time of admission, my lord, I got stay over the order of single bench. Now, my lord, kindly come to page 25 of the paper book. That is the offer of appointment. Page 25. It's offer of appointment. Because
It is lengthy.
No,
The order
no,
implemented.
no.
Can you paste the order?
Yes,
140,
yes.
page 140. Page 140.
না, আমাকে আমার মতো একটু বলতে দিন। Page 142. My lord, I start from the second paragraph. Mr. Hossein Laner, advocate, appears on behalf of the petitioner, and on earlier occasion, he had submitted his client has challenged office order dated 8/10th November 2017, by which Gonikhan Chaudhary Institute of Engineering and Technology, Malda, has terminated his allegedly probationary service with effect from the date. His first submission was that his client was appointed in the year 2013, and probationary period was of 2 years, after which he is deemed to have been confirmed. He next referred to rules regarding probation and confirmation appearing in annexure to this office memorandum dated 21st July 2024, issued by the Government of India, Ministry of Personnel, so and so, my lord, to submit. Even a probationer is entitled to be given an opportunity before taking drastic step of discharge. He submitted so far as favorable police verification requirement is concerned. His client had duly disclosed. He referred to disclosure made by his client as required at pages 34, 35, and 39 of the writ petition. He demonstrated his client had disclosed pendency of a criminal case against him, in connection with which he was arrested on 4th of August 2009 and granted bail on the same day. According to him, indisputably, this information was with his employer when it granted probationary service. He hence referred to pages 51 and 52 of the writ petition to work order dated 19 June 2017 to show the same was issued by Register Mentor Institute in Durgapur and signed by him only as holder of the post in which he was appointed probationer. He pointed out Deputy Registrar Finance Account NIT Durgapur had also signed so far as absence without leave allegation is concerned. He referred to paragraph 15C of the writ petition and submitted his client had taken leave upon intimation which cannot be said to be unauthorized. Mr. Jahan Lanet, advocate, appears on behalf of the institute and on earlier occasion had submitted. The first allegation is regarding involvement in police case dated 5th September 2015. He submitted this was after his appointment. On having created unrest in the institute, students lodged complaint against him. That is why the case was started. Today he relies upon page 30 of the affidavit in opposition of the institute and submit this report was considered by governing body, pursuant to which resolution was taken to terminate petitioner's probationary service. Probationary service gives
right to employer to assess competency, efficiency, and suitability of the probationer, whether to be appointed to the post. Till before appointment, probationer doesn't have any right to the post. So far as the first allegation is concerned, prerequisite of PVR appears to have been in favor of the petitioner, since disclosure was made of pending cases and other information acting upon which the institution appointed him. To find unsuitability on a police case subsequent to PVR for to be relied upon as per requisite of PVR not met, and that too without giving opportunity to petitioner to explain, is something that doesn't appeal to this court. A prerequisite cannot related to a subsequent event. Conspicuously absent from contents of impugned office order is resolution of governing body as informed to petitioner regarding reasons for termination of his probationary service as based on assessment of his competence, efficiency, and suitability. Law is settled regarding the aspect of service. In some cases, probationer not given any intimation regarding competence, efficiency, or suitability so as to improve himself or herself has also resulted in interference by the court. Question whether the petitioner stood automatically confirmed is, however, not gone into adjudicating, challenging to impugned letter of termination in view of circumstances disclosed above. For the reasons aforesaid, impugned order is set aside. The petition is allowed as above.
Now, what is this police complaint?
But there are two police complaints.
One PVR.
One PVR.
Disclosed in the police verification.
Disclosing the police verification.
There is a subsequent complaint.
In police verification, he disclosed in his attestation form. That's why let me place it, that would be better. Now kindly come to first the offer of appointment at page 25.
Page 20.
Page 25. It's a memorandum dated 9th of November 2013, by which this appointment was offered to the particular petitioner. Now, serial number 3, clause B. The appointment shall be against a regular vacancy, and the appointment shall be on probation for a period of 2 years initially. The period of probation may be extended at the discretion of the appointing authority. That was the precondition. Now, your lordship, kindly come to page 28. That is the appointment letter. In terms of offer of appointment, he joined the post, that is at page 27. He joined it on 13th of November 2013. And on that day, he submitted the attestation form, which was required in terms of our rules. Now, page 28, that is the appointment order. Subsequent to join. 23rd of January 2024. Now, same thing, that is clause 2.
So you said on the date of issuance of the letter of appointment.
Yes.
He joined after page 20.
First is offer of appointment.
So he joined page 20.
Joined page 27.
Along with annex.
Filing the attestation form.
That is not reflected in this joining.
No, that I shall show before lordship. That attestation form is there. There he disclosed that a case is pending. So suppression that I can't say. Page 27, then kindly come to page 28. That is the order of appointment subsequent to joining. That was our procedure. The clause 2 reflects this appointment is against our regular post. Sri Devhaldar will be on probation initially for 2 years, which may be extended at the discretion of the appointing authority. So, appointment in November 2014, and 2 years, that was the probation period, and extension, that option was there. Now, when this institution was constituted in 2010, that was placed, this is a central government funded institution. This was placed under the mentorship of NIT Durgapur. Now, for the first time in 2017, the regular director was appointed by the central government. Now, prior to 2017, there was no option to take any steps for confirmation of any probationary service of any of the staff of this institution.
Prior to the
joining of the regular director in 2017. And he joined on 7th of August 2017 for the first time. the regular director. Then the process for probation confirmation that started. Now this particular writ petitioner, my lord,
It is after expiry of 2 years.
after expiry of 2 years. Now, there would be a question whether by expiry of the period, there was any deemed confirmation or not. In 2014 till 2019, the law was that there was no concept of any deemed confirmation. After 2019, that came into picture. And this smaller termination is of 2018. So he was guided by the earlier scheme when there was no concept of any deemed confirmation.
Which scheme?
Regarding the central government came with 2019 circular, it says the maximum time of extension would be the double of the first initial probation period, that can be double in terms of extension, and there cannot be no further extension.
That circular came
in 2019. The case of this particular deemed conception that was brought in 2019, and he was terminated prior to 2019 when the concept of deemed confirmation that was not there. So we have proceeded treating him or considering him as a probationer.
At that time, under which rule you keep him under probation?
But there was no rule. I shall show the judgment.
There must be some rule.
No, CCA rule and 2014.
Keep one employee.
2014 rule was there. There was a series of judgment on this issue. Whether the concept of deemed confirmation would be there or not, I shall place those judgment. I have brought those. Now, kindly have a look to page 81. 81. There are the minutes of the 10th meeting of governing body. Regarding this confirmation. This was sometime in 2017 itself, my lord.
I just 20 September 2007.
Yes.
Yes, what you want?
Or kindly give me. My lord, kindly come to page 84. Agenda item number BOG 10.11. Lordship got it? The middle portion.
Yes.
Now, I to consider status on confirmation of employees of GKCIT Malda and police case against 2 employees. After thorough deliberations, Board of Governors approved the confirmation of those employees whose verification report are available and in order. The services of Sri Devhalda, the present writ petitioner before Lordship, Superintendent and MD Nur Alam Datta, data operator, cannot be confirmed because of the long-standing police case. Accordingly, directors should study their terms of appointment, probation, and deal with the aspect of their termination from service accordingly. This was the initial resolution adopted by the governing body. Now, after this, page 86, a fact-finding committee was, my lord, constituted on 10th of October 2017. A fact-finding committee is hereby constituted to inquire into the PVR and other conduct activity of Mr. Devhalda, Superintendent and MD Nur Alam, data operator GKCIT, with the following members. So 3.
Done under which guideline?
Maradu, we have no guideline. Because we can follow the CCA rule maximum. Because we are an institute, Maradu, we are under our memorandum of association.
Prior to 2018, there was no such scheme of confirmation.
No confirmation.
But was there any scheme or procedure laid down for confirmation?
Yes, 2014 is there. I shall produce that circular for Lordship.
2014.
14. And there was concept of dim confirmation that's not there.
No, but how to deal with?
Yes.
That was there.
That was there.
That is here included in the.
Not included, but I have brought all these things. That was relied by the writ petitioner at the time of hearing of the writ petition, but somehow that was not annexed.
Brought it on record. Anyway, please.
Now I will kindly come to the committee inquires into the documents related to the application and terms of appointment of these two persons, the alleged unauthorized absence of Mr. Devaldar, the details of tender processing file for engaging the outsourcing agency for providing security and cleaning, sweeping, so and so of involvement of Mr. Devaldar. Report submitted by the committee appointed for examining their PVR. So these 4 documents and aspects were placed before this committee to consider the fact before the fact-finding committee. Now your lordship will get the report of this fact-finding committee on the very next page, page 87. The fact-finding committee, they filed their report, my lord. A fact-finding committee has been constituted to inquire into the PVR and other conduct activities of Mr. Devaldar and Mr. Noor Alam, as per office order memo dated so-and-so 10th of so-and-so. Now, and the terms of reference are to be inquired into documents. The documents are there, my lord. Now, the fact-finding committee has met on 11th October 2017, chaired by Mr. Habib Masoom, assistant professor of so-and-so, and others name are there. The committee considered to examine the documents mentioned in I2, I4 to 4 above, which are provided by the assistant registrar, and also requested the director GKCIT Malda if he has any document other than above related to the inquiry. Upon request, director GKCIT Malda has provided few of the documents relevant to the case of Mr. Devaldar, Superintendent GKCIT Malda. The committee has examined the concerned files, documents therein with respect to the terms of reference in systematic manner in the meeting of committee held on 12th, 13th and 14th October 2017 as follows. The application form submitted by Mr. Devaldar and MD Noor Alam and their terms of appointment. Manada, I say this is a misconception on the part of the institution, because they say he ought to have disclosed, he suppressed regarding pendency of criminal case at the time of making first application. Our notification recruitment notice was there. There he applied. But they say examination of report submitted by committee appointed for examining the PVR of non-teaching employee. Now, based on the observation, just 3 paragraph below, based on the observation from 1 to C above, the committee examined the application. Page number so-and-so submitted by these 2 persons following observations made by the committee. Mr. Devaldar has a police case, Malda PS so-and-so, was FIR named accused, and this case ended in charge sheet by number so-and-so. Now the case is under sub judice. This fact was suppressed by Mr. Devaldar in his application for the post of superintendent at GKCIT. But there was no such space.
There was
no such space to mention all these things. Recruitment notice, in terms of recruitment notice, this writ petitioner applied. There was no column to disclose that the cases are pending against me. This is a misconception. But he had to say all these things while he filed the attestation form. And he duly made it. He duly made it, my lord. That I have to disclose before lordship. So there was no wrong on his part in respect of this. So suppression I can't say. Despite of pendency of a criminal case, whether we shall allow him to continue or not, that's a different aspect. Now, kindly come to page 88.
Report of the
Fact-finding committee.
What is source for report submitted by committee appointed for example? Where is this a separate committee?
Yes, it's a PVR. All PVR of all staff that was produced before a committee.
Before the committee at page 86.
Yes. Prior to this, a committee was formed for considering PVR of all the staff.
That is page 86.
Page 86. So page 86 is the present committee. Prior to this formation, there was a common committee for all the staff.
So this observation which has been recorded.
It's a wrong.
What is coming?
Not. Report is not attached.
Prior report not. Very good.
Now kindly come to page 88. The second allegations against this particular writ petitioner is alleged unauthorized absence. Now the following documents were examined. Attendance register of Mr. Devhaldar from 16th February 2017 onwards. Email sent to Mr. Devhaldar by the assistant registrar dated 4th September 2017 and the letter sent by Mr. Haldar dated 5th of September 2017. Memo dated 14th September issued to Mr. Devhaldar regarding stop release of his salary for the month of August 2017, asking him to account for his absence and provide any approval for such long absence from competent authority. Response submitted by Mr. Haldar dated 14th September, 15th September, along with 77 enclosures. So, but I have to admit before Lordship, no personal hearing was ever given to this writ petitioner. But that doesn't mean he didn't get any opportunity of representation.
What?
Because this shows, see, mail was sent to him, the notice was served upon him, he replied. So the right to response that he exercised. And there is enclosure of 77 pages made by this particular writ petitioner regarding his issue of unauthorized absence. No physical hearing was there, but representation that was there, my lord. Response, representation, those were there.
But there was no such representation pertaining to clause 1.
No, clause 1 that I have accepted for lordship.
Directly arrived at a conclusion.
That's a wrong conclusion. Clause 1 is a wrong conclusion. That should not be there.
Then?
Now, the conclusion portion of this, as no attendance register has been found in the attendance register of Mr. Devhaldar, no attendance or signature has been found in the attendance register of Mr. Devhaldar, superintendent since 16th February 2017. The documents submitted by Mr. Devhaldar were examined thoroughly by the committee as summarized in so and so. It observed that the proper leave approval is available only to extend of about 16 days. Maximum 27 days only as shown in the summary sheet. All other email correspondence and copies of meeting reports, etc. were enclosed, which doesn't support his remaining absence from campus during the period of 16 February 2017 to 4th August 2017 without proper leave approval as relevant. Now, kindly come to the third allegation. Examination of the documents of engaging outsource agency, that in
September to 4th August.
16th February to 4th of August. He was absent.
Was he paid salary?
From August, that was stopped.
August,
it was stopped. In between, my lord, communications were there. He submitted documents wherefrom it appears only there was leave for 16 days.
Prior to this order, his salary was stopped.
Salary was stopped.
Prior to this order.
Prior to this order. Now, kindly come to 3, the examination of documents of engaging outsourcing agency, because it involves, my lord, huge fund, around 2.73 crore, if I'm not wrong. The committee examined all 85 documents handed over by the NIT Durgapur, because they were at the point of time, they were our mentor director, in concerned file of tender for engaging the outsourcing agency for providing security and cleaning, sweeping and housekeeping services. An office memo number so and so was issued by the competent authority asking Mr. Devhaldar to submit the complete report of the engagement tender process followed vis-a-vis rules and regulation in force at GKCIT under the MOA as well as CCS rules for the said tender, and subsequent submission of Mr. Devhaldar dated so and so. From the examination of these documents, following facts came out. The security and cleaning, sweeping and housekeeping service manpower requirement has been shown even for buildings which are under construction or not operational. Also, one of requisition sheet was not signed by anyone. A note sheet dated 4th of April 2017 was submitted by Mr. Devaldar for a total manpower requirement of 108, including financial involvement estimated rupees 2 crore 87 lakhs odd per annum. These documents do not provide any administrative financial approval by the mentor director, mandatory approval from the finance committee and the BOG of the GKCIT for the rising number of manpower and huge financial implication. From one of the email copies submitted by Mr. Devaldar in respect of two above, it clears that AR instructed him to follow the due procedure. Contextually, it observed from the previous work order that there was 71 personnel required under an outsourced agency, namely Swansea, for providing security and cleaning and housekeeping service, but only 64 persons were working at the time of this tender process. However, the contract of ISO was valid up to 29 June 2017 after providing extension. The tender was processed as seen in the enclosure page and work order was issued by memo dated so-and-so, which was duly accepted by outsourcing agencies. It is seen in the submission of Mr. Devaldar in respect of the office order memo dated so-and-so that he has not provided any reply to the specific question asked by the competent authority and claimed no knowledge of relevant rules under the MOA, GKCIT and CCS rules. CCS rules were violated by not taking instruction from his reporting officer, by not fully involving Mr. Subhashis Datta, the then professor in charge, and violated the rules and regulations. Now, finding of the committee subsequent to the, there is a smell of scam. The finding of the committee in respect of Mr. Devaldar, superintending GKCIT Malda. First, Devaldar suppressed information about police case. I can't accept this one. This has to go. Now, second, in service at GKCIT Malda, Mr. Devaldar, superintendent, has police case dated 5th of September 2015. While discharging his duty in this institution, he involved himself with some kind of criminal activities leading to arrest warrant, and he surrendered before the learned court on 31st of August 2017, and he is continuing appearance before the court. It is shocking to note from the FIR that being a security officer, he himself led attack on institute students by the outsiders. Mr. Devaldar remained on unauthorized absence for long period during 16 February 2017 to 4th August 2017. Mr. Devaldar has almost independently got the tender process done for engagement of outsourcing agency to provide this security and cleaning so-and-so service without the mandatory approval from the concerned institute authority, that is the finance committee, so-and-so, so-and-so. Now, based on this, my lord, if your lordship stands to termination.
Court said that it cannot be taken into consideration.
That's the wrong concept.
Why you are saying?
Because my probationer service.
Because his entry into probation was on the basis of disclosure that there was a criminal.
Yes, yes.
That you are also agree.
Yes.
So the learned single judge has proceeded on the basis, if you can come to 144.
Yes, my lord.
Last paragraph. Probationary service gives right to assess competence, etc. Whether to be appointed. Till before appointment, probationer does not have any right. So far as first allegation is concerned, prerequisite of PBR appears to have been in favor of it. Since disclosure, now this one. To find unsuitability in a police case subsequent to PBR.
I am not going by that.
Because that is.
I am not on that.
Clause 2.
4 clauses are there, four allegations are there. I am not going by the first one. Second, my lord, I shall based on some judgment.
Second one is the FIR which was lost.
Yes. So, my lord, that is to consider his conduct. My lord, to confirm probationary service, competency as well conduct.
When the conduct you are assessing on the basis of a police allegation.
Yes.
Right to face a departmental procedure.
Yes. Yes.
But whether you can take it as a ground for non-confirmation.
Non-confirmation, my lord, I say yes. But allow me to proceed. Yes. And there are two other grounds, Your Lordship. Out of 4, the first I concede because that's a wrong conception.
What is your stand? Are you accepting the finding of the judge as so far as clause 2 is concerned, relating to the police case?
No.
In continuous.
No, I am not accepting.
All right, you elaborate on that now. What other grounds?
One is unauthorized absence for a long period, and third is my involvement in a tender process, wrong tender process. Or yes. Now, kindly come to the termination order.
Yes, please.
Termination order টা কোথায় আছে আমার এখানে? That is page 50. I have shown before Lordship the 10th BOG, whereby the director was empowered to conduct inquiry.
No, you have not shown.
10th BOG I have shown before Lordship. Just at page 81.
Sorry. Page 84 onwards. Starts from 81.
81. 10th BOG, but by which the director was empowered to proceed. Based on this, the fact-finding committee, others, all these things came into picture. Now the termination order.
Empowered to proceed. Who has given you?
The BOG. BOG directed or asked the director to proceed.
Where is that line? Page 80.
Page 84, my lord. The last two lines. Accordingly, the director should study their terms of appointment, probation, and deal with the aspect of their termination from service accordingly.
Page 84, last 2 lines.
Confirmation, who is the authority? Board of Governors.
Board of Governors. Board of Governors. Now, after this, my lord, fact-finding authority reports everything, that was placed before the BOG in its 11th meeting. 11th BOG. But that document I didn't submit, my lord. But my lord, your lordship will get it from page 50 itself. 50. In the termination order, there is a reflection. We have quoted the view of the BOG, my lord. The Board of Governors, Malda, West Bengal, in its 11th meeting, held on various agendas, held on 7th of November 2017, in Ministry of Human Resource Development, so while taking decision regarding confirmation of service of staff of the institution on completion of probation, inter alia decided not to confirm service of Mr. Devaldar, superintendent, due to adverse police verification report. The Board of Governors further decided to terminate probationary service of Mr. Devaldar with immediate effect from the reasons recorded in the said resolution, which is reproduced herein below. So these are the things quoted from, my lord, the resolution.
Which is the adverse PPR? There is no adverse.
Adverse PPR is pendency of case. That is itself adverse, my lord. Now it is noted that Mr. Devaldar, it speaks about the first and second criminal cases. Now the second paragraph.
Yes, in that process.
Yes, in second paragraph, in addition, it is also noted that pursuant to the last BOG meeting, a fact-finding committee was formed by the director GKCIT. From the committee report, it is noted that he was absent unauthorizedly. He has also been involved in doing a tender without the proper authorization from the competent authority. It is noted that the contract work order valued rupees 2.73 crore was issued without taking any approval from the FC or BOG. Thus, not only there was no proper authorization for entering into such high value financial commitment, but also that a proposal financial outgo was for a value of above 4 times the earlier financial outgo on a similar activity. So on this issue, they decided not to confirm the probationary service. Now, my lord, I must inform your lordship that ultimately by the intervention of Ministry of Human Resource and Development, who are our superior, my lord, that particular tender process that was ultimately scrapped at a later stage. Because they also detected, yes, there is something wrong. Now, this termination order is before Lordship. Now, the first question, the first hurdle is whether the non-confirmation of probation can be done with some allegation. Because if this question is put, probably I would have no answer to this. Because we know our non-confirmation must be simpliciter. If there is allegation, it's not permissible. But it's a special case when the involvement of unauthorized absence is there, for which he got ample opportunity to give his response, as it appears from the record. He responded by representation as well as email. And regarding involvement in unauthorized tender process of 2.73 crores, where is the smell of scam. Now, I say a part of this, that the first clause, there are also two things. One is of 2009 case, which he disclosed, and 2015, which happened subsequently. Now, if your lordships allow me, I will rely on single judgment.
On the issue that
On the issue,
confirmation can be
no, it says even after disclosure, even a candidate disclosure is made, the authority can deny the appointment itself. If there is any pending criminal case, if it is disclosed, even then they have a right to deny.
That is a wrong submission. That there was a disclosure, there was no suppression.
No suppression.
So even if there is no suppression, relief can be denied. Confirmation can be denied.
I say appointment can be denied. If appointment can be denied, my lord, I say the confirmation also. That would be my subsequent. Finally, come to para 69. Paragraph 69, my lord.
Without holding any proceeding.
Yes.
Para 69.
Para 69. In such circumstances, we undertook some exercise to shortlist the broad principles of law which should be made applicable to the litigations of the present nature. 69, dada. 69. Pagination nahi, eta mushkilta. The principles are as follows. Now, the first one is A. Each case should be scrutinized thoroughly by the public employer concerned through its designated officials, more so in the case of recruitment for the police force who are under the duty of so-and-so, so-and-so. Now, B. Even in case where the employee has made declaration truthfully and correctly of a concluded criminal case, the employer still has the right to consider the antecedents and cannot be compelled to appoint the candidate. The acquittal in a criminal case would not automatically entitle a candidate for appointment to the post. It would be still open to the employer to consider the antecedents and examine whether the candidate concerned is suitable and fit for appointment to the post. Now, here is a case. But he got the appointment prior to disclosure. Kindly take note of those dates. Well, kindly.
Offer of appointment was in 2013.
Yes. Our offer of appointment at page 25 on 9th of November 2013. Till that day, there was no disclosure. Now he joined the post on 27th.
How we are to show that there was no disclosure?
Because
Page
he
25 is the
offer of appointment. Pursuant to that,
he joined in
on 13th of November. On that day, he submitted his attendance.
Where do we find that?
Kindly come to page 31. 31. That is his attestation form.
Is there any date?
Page 36, that was the signature.
12th November.
12th November, he signed it and he submitted this along with his joining. That was the procedure. So, my lord, prior to offering appointment, we didn't have the knowledge of this pendency. I can't say it's a suppression. The point which has been taken in that's a wrong. But while, my lord, we have offered his appointment, we didn't have knowledge of this. Now, the Satish Yadav says, even if truthful disclosure, that doesn't, my lord, take away our right to consider. Now he was appointed, he continued. We got first opportunity to consider over the issue after getting our regular director. Now 10th BOG, PVR, then we decided.
অবতার সিং কনসিডার করে দিয়েছে।
Now the question,
That was not an argument before the single judge.
before the single judge, well, the regarding
review.
But we have filed, yes, well, remind it back. Remind back, Malak. Because I am before the appellate authority. I am before the appellate court. I am taking all these points before Lordship because these are the judgment. Now, 2014 circular. Now, if we go to the extent of whether he was in probation or not.
Of law is that the authority, when if there is a truthful disclosure, the authority can take into consideration such fact for the purpose of appointing the person. You are arguing that the PVR, though there was no suppression, that leaves a right upon me to discontinue his
Not to confirm. Yes.
Confirmation stage and appointment stage are different riders altogether in service jurisprudence.
But if a person is not entitled,
not suitable for the job.
Yes.
His only element is suitability. If it is that suitability simply stated, you can discharge.
Now, one thing which was not suitable to get an appointment.
It is subject to what you are.
Yes, madam.
But adding on terms to the issue of suitability. Yes. All is very clear. Suitability, simplicity, no interference. But once your opinion is backed by a finding on issues which requires deliberation, whether tender process was wrong, whether there was a conspiracy, whether there was direct involvement, these are issues, Mr.
There I say, my lord, it was not a case that he was not given any opportunity.
When he responded to the presentation which was
So, my lord, the opportunity of response that he got.
All right. Yes, next, what is your argument?
Now, my argument, if your lordship, he was a probationer. He was a probationer. Now, this issue was not gone into by the single judge also. He said, we are not disclosing or adjudging that issue. Now, if your lordship takes up the circular of 2014. of probation.
Your next argument is?
He was in probation. Because I say there was no concept of deemed confirmation. Now, on this 21st July 2014, it's probation and confirmation, the second page your lordship will get. It's 21st July 2014.
Second page.
Second page. No, the document which I have submitted. No, the rules.
Document?
Rules. Yes.
What is this?
This is the central government notification, office memorandum regarding confirmation and probation.
This was not brought on record before this.
That was argued by them before the single bench, and there is a reflection of the same.
Yes.
Now the second page, kindly come to second page, probation and confirmation. A person is appointed on probation in order to assess his suitability for absorption in the service to which he has been appointed. Probation should not therefore be treated as a mere formality. No formal declaration shall be necessary in respect of appointment on probation. The appointing authority may declare successful completion, extend the period of probation, or terminate the service of a temporary employee on probation on the basis of evaluation of performance. That was in vogue at the time of considering the petitioner's case. Now, paragraph 2, probation is prescribed when there is a direct recruitment, promotion from one group to another. The probation shall stand successfully completed on issuance of order in writing. It is, however, not desirable that the government servant should be kept on probation for a long period. But a written order is required. Now, period of probation, the direct recruitment, clause 3, it says for direct recruitment to the post except clause so and so 2 years. Here is a case of 2 years. Your lordship will not get a single sentence in this particular memorandum that there was any concept of deemed confirmation that was in existence, or there was maximum limit for extension. The initial period for 2 years that has been given, the first paragraph says that the extension is possible. The appointing authority may declare successful completion, extend the period of probation. So the extension power that was with the appointing authority. The termination was also there after evaluation.
10.
All right? Termination of probation. The decision where an employee should be confirmed on his probation extended or his probation extended should be taken soon after the expiry of the initial probationary period, that is within 6 to 8 weeks, and communicated to the employee together with the reasons in case of extension. A probationer who is not making satisfactory progress or who shows himself to be inadequate for the service in any way should be informed of his shortcoming well before the expiry of the original probationary period, so that he can make special efforts at the self-improvement.
11.
On the expiry of the period of probation, steps should be taken to obtain the assessment reports on probation 2, confirm the probation, issue order regarding satisfactory termination of probation, as the case may be, if the probation has been completed to the satisfaction of the competent authority, or extend the period of probation or discharge the probationer or terminate the service of the probationer, as the case may be, in accordance with the relevant rules and orders, if the probation has not completed the period of probation satisfactorily. So your lordship will not get any concept of deemed confirmation. That is missing. Dayaram.
What you will do?
2014 rule. আপনাদের লোকই যায়।
সাথেরও তো কিছুটা আছে।
এটা কি ব্যাক টু ব্যাক নাকি? আমি কি করবো? কথা
In case of Doyaram, that was reported in 1997, volume 7, SCC, page 443. ওটাই তো দিলাম।
97
Volume 7. No, I'm relying on 1997, volume 7, SCC, page 443. The same thing. Yes, yes, equivalent. Or kindly come to paragraph 8 onwards.
Yes.
Paragraph 8. Can give me 1 second. One line of cases has held that if the rule or order of appointment, a period of probation is specified and a power to extend probation is also specified, and the officer is continued beyond the prescribed period of probation, he cannot be deemed to be confirmed, and there is no bar on the power of termination of the officer after expiry of the initial period of probation. In the case before the Constitution Bench of this court, in Sukhbir Singh, state of Punjab, so-and-so of the relevant rules provided a period of probation and contained a provision for extension of probation. Rule 23 of termination during probation and Rule 24 of substantive appointment on completion of probation. It was held that a probationer cannot automatically acquire the status of a permanent member of a service unless, of course, the rules under which he is appointed expressly provide for such a result. The rules governing the provincial civil service and of Punjab do not contain any provision whereby a probationer at the end of the probation period is automatically absorbed as a permanent member of civil service. At the end of thus probation, he is merely qualified or eligible for substantive permanent appointment. Thus, termination after expiry of initial power of probation was held not invalid. Another Constitution bench followed the above judgment by G.S. Rameshwar, IG of Police, Mysore, to say that the Rule 486 of the relevant Hyderabad rules didn't provide for automatic confirmation after 2 years of probation unless the officers have given satisfaction. Similarly was the position in the case before the another Constitution bench in state of UP versus Akher Ali Khan. Here also the court held that on completion of 2 years probation, as per rules, the officer continued to be probationer until an order of confirmation was passed. Sukhbir Singh, a case was followed and it was stated that unless the order of appointment or the rule said that at the end of probationary period, if no order was passed, the officer is to be deemed to have been confirmed, the officer continued to be on probation. We may state that the facts in Kedarnath decided by a 3-judges bench are also similar, and the earlier rulings set out above were followed. In Dhamijbhai versus state of Gujarat, also the period of probation fixed under the rules was 2 years, and there was also provision for extension, but no maximum was prescribed. The termination was after the expiry of the period of 2 years of probation. A 3-judges bench took the view that there could be no automatic confirmation at the end of 2 years, and the termination after 2 years was valid. Now, the second limb that was discussed, and ultimately this court reached no. If a maximum period is mentioned, it should be deemed that on expiry of that maximum, he should be treated as confirmed. That was the view in this Doyaram. Now, that was overruled. The first line, if your lordship take us the first page, this judgment has been overruled by High Court of Madhya Pradesh. That has been cited. I am citing that judgment. Madhya Pradesh.
বল তাহলে বল না কি অসুবিধা কি তোর তো বলার অধিকার আছে না তাহলে আজকে আমি বলতে দিবি না
আমাকে প্রত্যেকটা জাজমেন্ট আমি সাপ্লাই দিচ্ছি, তারপর এরকম করে আমাকে ঠুকছো তুমি। Which one? Then kindly come to page 35. I shall rely on my 35 and 37. In the case on hand, correctness of the interpretation given by this court to Rule 24 of the rules in the case of Doyaram Doyal, which I have cited earlier, in the bone of contention, is the bone of contention. In the aforesaid case, no doubt this court has held that a maximum period of probation having been provided under the sub-rule so and so, if a probationer's service is not terminated and he is allowed to continue thereafter, or paragraph 35, my lord, at page 22.
About 36.
In the case on hand.
That is 36.
36.
Well, kindly go to page 35. They are also in the case of hand. The two paragraphs starts with the same sentence, same word.
In 35, in the case of Doyara.
Doyaram Doyal, 65.
Just give me a second. The kitchen problem.
But 36, bone of contention, the words.
Yes, yes, page 36. There is some mismatches.
Ah.
They were downloaded from another version.
Okay,
So there was
yes,
some.
yes.
Well, kindly.
36, yes.
36. In the case on hand, correctness of the interpretation given by this court to Rule 24 of the rule in the case of Doyaram Doyal is the bone of contention. In the aforesaid case, no doubt this court has held that a maximum period for probation having been provided under sub-rule 1 of Rule 24, if a probationer's service is not terminated and he is allowed to continue thereafter, it will be a case of deemed confirmation, and the sheet anchor of the aforesaid conclusion is the Constitution bench decision of this court in the case of Dharam Singh. But in our considered opinion, in the case of Doyaram Doyal, Rule 24 has not been interpreted in its proper perspective. A plain reading of the different sub-rule of Rule 24 would indicate that every candidate appointed to the cadre will go for initial training for 6 months, whereafter he would be appointed on probation for a period of 2 years, and the said period of probation would be extended for a further period not exceeding 2 years. Thus, under sub-rule 1 of Rule 24, a maximum period of 4 years probation has been provided. The aforesaid sub-rule also stipulates that at the end of the probation period, the appointment could be confirmed subject to his fitness for confirmation and to have passed the departmental examination as may be prescribed. In the very sub-rule, therefore, while a maximum period for probation has been indicated, yet the question of confirmation of such probationer is dependent upon his fitness for such confirmation and his passing of the departmental examination by the higher standard as prescribed. It necessarily stipulates the question of confirmation can be considered at the end of the period of probation, and on such consideration, if the petitioner is found suitable by the appointing authority and he is found to be past the prescribed departmental examination, then the appointing authority may issue an order of confirmation. It is too well settled that an order of confirmation is a positive act on the part of the employer, which the employer is required to pass in accordance with the rules governing the question of confirmation, subject to a finding that the probationer is in fact fit for confirmation. This being the position under Rule so and so, it is difficult for us to accept the proposition broadly laid down in the case of Doyaram Doyal, and to hold that since a maximum period of probation has been provided thereunder, at the end of the period of probation must be held to be deemed to be confirmed on the basis of the judgment of this court in the case of Doyaram. Now, next paragraph, probably that would be paragraph. Give me 1 second. 37. My 37 starts with ordinarily. Yes, ma'am. Kindly come to page 30, paragraph 38 now. Ordinarily, a deemed confirmation of probationer arises when the letter of appointment so stipulates. or rules governing service conditions so indicate. In the absence of terms in the letter of appointment or in the relevant rules, it can be inferred on the basis of the relevant rules by implication, as was the case of Dharam Singh. But it cannot be said that merely because a maximum period of probation has been provided in service rule, continuance of the probationer thereafter would also, or would ipso facto must be held to be deemed confirmation, which would certainly run contrary to the 7 judges bench judgment of this court in the case of Shamsher Singh. So my contention would be before Lordship that since there was, in my case, maximum period for extension that was not there, condition or the clause or proposition for deemed confirmation that was not there, so he cannot be treated as confirmed even after expiry. Now, this being the situation, I say before Lordship that the particular writ petitioner, while was in confirmation or in probation, he was proceeded against, he got opportunity to respond, and ultimately the governing body was of the opinion that he is not fit for confirmation because his conducts and other things shows that goes, my lord, adverse to the interest of the institution. Accordingly, he was terminated and termination order is correct.
Thank you. Yes. Millard, the issue, Millard, that is being centered around, Millard, and which Millard weighed with the Honorable Single Judge, Millard, while deciding the writ petition, Millard, the first and elementary thing was that whether the termination could have been made in such a way so far as a probationer is concerned. The foundation and motive, Millard, these are the two fundamental principles, Millard, which governs.
The point of deemed confirmation.
I was not there, Millard. I don't know.
The order we don't.
No, I can't say anything, Millard. I must make a responsible statement, Millard. Today, Millard, the foundation and motive, the termination contains certain allegations, which entails, Millard, which essentially, Millard, takes to the point of, Millard, that the element of misconduct is there, and for which, in any form of the service, either he is a probationer or, Millard, permanent, an inquiry is necessary. I will show the Constitution Bench judgment headed by Justice P. Gajendra Kumar. Second point, Mr. Jahan, my learned esteemed friend, Millard, has taken to your Lordship's, Millard, the fact-finding committee report. He, Millard, by reason of his inherent fairness, has said that so far as the suppression is concerned, Millard, I cannot take this point. Mr. Jahan also, Millard, had taken my lord's kind attention to the fact of the Satish Sharma and this particular paragraph 69, Millard. In that case, Millard, the constable had suppressed, Millard, his antecedent, even he is convicted. So the case has to be decided on the factual matrix. In that case, even, I assume, Millard, but not admitting, Millard, the observation, even it is obiter, Millard, passed by the Supreme Court, and even it is binding according to him, Millard, the other clauses of the page paragraph 69, it says, Millard, the authority will also consider, is there any element of the court will also consider in the judicial review court, the element of bias, and whether the decision was, Millard, fairly taken. The element of fairness and element of bias, why I am telling to your Lordship, if your Lordships kindly take pain to turn page 127, your Lordship will be pleased to find that an inquiry was directed to be conducted by my client while he was acting as an assistant registrar. Why I am telling? Because these gentlemen, 127. This was issued by the Goni Khan Chaudhuri Institute of Engineering and Technology in the interest of Institute. Sri Dev Haldar, that is the petitioner appellant before respondent before your Lordships, writ petitioner, is given the charge of assistant registrar during the absence period of assistant registrar in addition to his own duties. Kindly take note of the in addition to his own duties. This come into force with immediate effects until further orders. This issue is with the approval of the competent authority. A probationer, after 4 years, Millard, completion of his service in a probation, on a probation, he was Milord, I don't know, Milord, whether this honorable court has ever come across that whether a probationer has, Milord, been assigned to such a post duty, Milord, more particularly the post of, Milord, the assistant registrar. This inquiry was conducted, Milord. Your Lordship will be pleased to find page 129. I have a reason, Milord, to show this to your Lordship for the simple reason 129, clause 1, irregularity in appointment of regular staff. Irregularity on appointment of regular staff. This is, Milord, the inquiry that was conducted by my client, the writ petitioner, in terms of the direction given by the professor in charge.
After such appointment.
After 13 is the appointment, 127. 127 is the direction you do this inquiry. 128 report starts. My client, writ petitioner.
Test of institutes given charge as assistant registrar.
Yes.
Where is the duty to conduct an inquiry?
But the duty to Milord to conduct an inquiry because this was Milord in addition to his own discount. Now, Milord, this is Milord a consolidated report on the irregularities made by the describing the reasons of the present situation of the institute. With due respect, the kind notice that the irregularities have been observed during the execution of the tasks assigned to me. This was not addressed. The point-wise details are as under. Irregularity in appointment of regular staff. Clause 1. Finally comes to the last paragraph with the same page. 4 numbers of assistant professors have been recruited without requisite qualification as per guideline of the University Grant Commission for General Science and Humanities. Shiv Shankar Chaudhuri, Dipanjan Das.
This is your report. This is the report at page 132 of the security officer.
I was appointed as security officer. The appointment letter.
But when additional charge as assistant registrar.
In the interest, superintendent is given in the charge of assistant registrar during.
This inquiry as a superintendent or as an assistant registrar?
Milord, that is, Milord, that is not clear. I said, Milord, that this is Milord, this is now, it was a report on the irregularities made in the institute describing the reasons of the present. With due respect, it is to bring to kind notice that many irregularities have been observed during the execution of the tasks assigned to me. Milord, this report was filed by me. This is a report. Be that as it may, I take it that I will not travel beyond the language. It indicates, Milord, in no uncertain times, irregularities in which, Milord, in clause number 3, Sri Bikorno Tarokdar appointed as an assistant professor of mathematics, qualification MSc in math. He is one of the persons, Milord, who, Milord, according to my report, lacked, Milord, qualification. His appointment was irregular. Then, Milord, 131. During preparation of summarized details of individual employees, a file application containing 10 to 12 application for assistant registrar was found. From the file, it has been observed that many candidates had applied for the assistant registrar who have already been working as an assistant registrar in other government universities, but they were not called for interview. Only 3 applicants were called for interview, including Muhammad Abdul Razzaq. Other 2 had no working experience, so the appointment of Abdul Razzaq as assistant registrar is also under question. Then, Milord, Mr. Jahan, my learned esteemed friend, had taken my Lord's kind attention to the fact-finding committee's report at page 86. Milord, I start from, Milord, page 86. A fact-finding committee is hereby constituted to inquire into PVR and other conduct activities of Mr. Dev Haldar, Superintendent, and Muhammad Nur Alam, data operator, such and such. In inquiry committee was consisted of 3 persons, 2 of them Bikorno and Abdul Razzaq. This was report dated, Milord, 10/10/2017. 10/10/2017. And the report which I have filed, Milord, that is my report. Yes.
And those names Any allegation against these three persons?
My lord, in my report, these two persons who were the committee members, Bicorno 2 and 3 and Abdul Razzaq. Bicorno, Abdul Razzaq. Yes. My lord, page is at 125, 128, 129. Sorry, my lord. একটু দাঁড়া হ্যাঁ তাই না 129. 4 numbers of assistant professor have been recruited without requisite qualification as per guideline of the UGC rules for general science and humanities. Page 130, Bicorno Tarafdar. My lords got it. Bicorno Tarafdar, and 131 last, Muhammad Abdul Razzaq. He is also a person, my lord. I said, my lord, the qualified candidates who applied for the post of assistant registrar were not called for interview. Mr. Jahan, my lord, his client is a whistleblower, and he expressed his anxiety saying, Miller, this smacks of corruption. I will deal with him in the next phase, that this is, Miller, the person concerned. The person became the judge of their own cause. The moment May 2017, I filed a report, and 10, Miller, with an ultrasonic speed, Miller, such response, such celerity, Miller, is absolutely, Miller, unwanted. And not only that, it also is not doubtful. Miller, this writ petition in the affidavit, in reply, I have said, Miller, in reply, I also make a cause. I said, Miller, the fact-finding committee. In reply, I have said so. Miller, today, my first point, I repeat, at the cost of tiring repetition, the foundation and motive, I will show a judgment, Dipti Prakash, how the Supreme Court and the settled law. Next, Miller, Mr. Jahan, my learned esteemed friend, because Mr. Jahan, Miller, Mr. Jahan has, my lord is possibly talking to. I am interrupting your lordship. Mr. Jahan has passionately relied upon Millard's paragraph 69 of Satish Sharma. Satish Sharma is not confined to only one, that even the statement is truthful or correct. The court did not end its journey, Millard, there. The court, Millard, proceeded further. Court said the element of bias, Millard, that is in the authority's decision. The element of fairness in the decision. It is a question of. Yes. Judgment. ওটা কোথায় রাখছিস? Satish Sharma, 69. May I read for my lords? Each case should be scrutinized thoroughly. Mr. Jahan Miller, my learned esteemed friend, relied on B. Even in a case where the employees has made declaration truthfully and correctly of a concluded criminal case, the employer still has the right to consider the antecedents and cannot be compelled to appoint the candidate. The acquittal in a criminal case would not automatically entitle a candidate for appointment to the post. It is, Millard, pre-appointment case, the consideration. It would still open to the employer to consider the antecedent, examine the candidate concerned is suitable and fit for appointment to the post. Or are, Millard, these conditions are pre-appointment. My journey, Millard, started in 2013. The offer appointment, my joining 2014, and Millard, 2017. I was, Millard, a delegated a duty as assigned the task of, Millard, assistant registrar. So, Millard, today it is too late in the day, even if I assume, but I do not admit, Millard, that Mr. Jahan's understanding of 69 subclause B is confined to appointment, then it obviously relates to, Millard, pre-appointment stage. That before the appointment is made, I will exercise my due diligence. The government cannot take privilege of its own irresponsibility. The government, after 3 years, when Millard, what Supreme Court had said, Supreme Court was conscious and not unmindful of its times. Kindly seize, Millard. The court should inquire whether the authority concerned whose action is being challenged acted malafide. It means it is ill-intended. Malafide, Millard, the simple English is ill-intended. Is there element of bias in the decision of the authority? Mr. Jahan's submission.
First tell us, is it your argument that it is a case of deemed confirmation?
Yes, Millard, also.
So then clause B applies in your case.
I said, Millard.
Because I asked the issue that this clause B is pertaining to the appointment. person.
I said pre-appointment. I was appointed. Now, so far as where it starts, it says, my lord, that there cannot be a concept of deemed confirmation. Why? Because Rule 2014 was read. Now, Rule 2014, Rule 8, there was a certain duty that is cast upon the authority that what are the procedures. And, my lord, the first page, I will come one after another. My lord, if I am first pursuing, all said and done, the termination is a foundation or motive. If it contains stigma, my lord, all other actions, my lord, court will not look into. I will, my lord, tomorrow, my lord. Tomorrow, my lord, let it be continued, my lord. Subject to convenience, my lord, 2 p.m. তুই চলে যাস আমি লোকটা আমার জানা দরকার নেই আমি মামলা শেষ করতে চাইছি I am deeply obliged, deeply obliged.
Mr. Jahan, finish it up.
But I have already. Only I will give reply for 5 minutes.
You will give reply.
Yes. A reply that cannot be malodor. A very short reply.